Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5127. Washington Lawyers Committee for Civil Rights and Urban Affairs Appellant versus United States Department of Justice. Mr. Stafford for the appellant, Mr. Fulham for the appellate.
Good morning, Mr. Stafford. You may proceed when you're ready.
Thank you, Your Honor, and may it please the court. As the district court recognized in this case, WLC stated a valid policy or practice claim under FOIA against BOP. BOP's FOIA violations are pervasive. Requests channeled through BOP's general FOIA pipeline, including requests on behalf of inmates merely seeking their own prison record, go unanswered for months or years, way beyond the time permitted under FOIA. This pattern of violating FOIA's timing mandates is especially harmful for prisoners seeking to vindicate their constitutional rights or hold prison officials accountable for abuse. Despite finding that WLC stated a valid claim, the district court immediately granted summary judgment to BOP without any discovery, based on a single affidavit from a BOP official. But the affidavit only raised more questions than answers, as it confirmed that BOP is capable of adjusting its channeling policy to comply with FOIA's deadlines for certain individual requests when it wants to. The district court's grant of summary judgment should be reversed in this case. I'd like to start with the correct framework for analysis in this case, because I think the parties have some dispute about that. In our view, the correct analysis comes from this court's decision in Judicial Watch, and the question is whether the agency has a policy or practice that results in persistent FOIA violations and will interfere with WLC's rights in the future. If so, the agency has a burden to, number one, explain its delay, but number two, also confirm how it intends in the future to conform to FOIA's mandates. So in this case, the evidence shows that BOP has a policy of unnecessarily and selectively funneling requests for individual records behind requests for systemic records, which create massive delays.
So can I just back up and ask about what you think the legal test is? So effectively, the government and the district court proceeded as if it's enough if the agency shows it's addressing requests in good faith. And I just want to make sure I understand your argument. Are you arguing as a legal matter that that's not the right test? Or are you just arguing as a factual matter because of the channeling policy and I think the arguments you were about to get into that there's doubt about agency good faith here?
I'm arguing the former, Your Honor, that that's not the correct legal test. The good faith language is coming from this court's decision in Open America, which, as we sort of explained in our reply brief, is a case interpreting the exceptional circumstances provision of FOIA. And BOP did not invoke that exception in this case. It didn't raise it in the district court.
So when we ask, is the government's explanation adequate under the statute? What is the metric what's the statutory standard we're measuring that against?
So you're looking to see whether the government has explained the delay, but also in a policy or practice case, you're looking to see whether the government has adjusted its policies so that it can conform to FOIA's mandates in the future. So we don't think there's any.
I think that's the question. What does it mean to comply with FOIA's mandates in the future? One test, which you seem to have avoided, would be they have to show they're satisfying the exceptional circumstances standard. That's the standard the statute provides for justifying a lengthy delay in production. But you haven't offered that as the test. And you've said words like bring into compliance with the statute. And I just want to know which provision is being violated, which provision do they have to explain they're going to comply with?
Yeah, so they're violating the timing mandates in A3A and A6A. And the language I'm using is the language that the court used in Judicial Watch. I think the court does talk about the exceptional circumstances provision, but the reason we're not really invoking that is because that's typically used for individual records requests where the agency will have sort of a more specified reason for the delay with respect to an individual record. In our case, we're really focused on the policy or practice, and we're looking for sort of a broader injunction that would have the agency modify the practice itself.
So A6A is about the timing for the determination.
Correct.
So your suit is about forcing BOP to make determinations, not produce the records?
Correct, Your Honor, because I mean, we're looking for both. We're looking for the determination and the production. They haven't done either. But what happens is whenever my client sends a request to BOP, we get a tracking number and then we get sort of nothing in response for months or years. So we're looking, both to the determination requirement and also the production requirement, which I think this court's recognized as, promptly means days or weeks, not months or years.
So, Mr. Stafford, what distinguishes the circumstances that we're facing here from that of every other agency that has a FOIA backlog? If we were to rule in your favor, does that mean that every routine FOIA requester who's, repeatedly coming back to the agency for a similar category of records and who routinely has to wait more than 20 days to hear about the request, is every person in that situation, by making those allegations, going to be entitled to discovery and potentially an injunction based on allegations that the agency should be using an alternative, expedited, or non-FOIA process to release the records?
I think in this case, Your Honor, it's a little bit unique in that we actually have record evidence showing that the agency is capable of using these alternative procedures. I mean, they have this streamlining process for individual medical records requests that they have sort of developed over the course of this litigation. And in our view, this sort of shows that the agency, unlike most agencies where perhaps they are constrained by they are going as fast as they can, this case is just different because of the fact that we have the evidence showing that they can go faster when they want to. And in that circumstance, we think that, we should at least get discovery into the extent of that policy and, whether it's necessary to limit it to individual medical records and how the agency can sort of allocate its resources appropriately.
I'm a little confused by your claim that the FOIA violation is the channeling policy, by which I take you to mean the policy of requiring the requesters to go through FOIA. And it just seems perplexing to me that the notion that requiring FOIA is a violation of FOIA and that the remedy under FOIA should be to use some different policy. And I take you to be referring to Privacy Act policy?
Yeah, so Your Honor, I'm happy to clarify that. So all of the requests for records have to go through FOIA under BOP regulations. So what they've done is they've created a streamlined process that allows for more expedited processing of certain individual medical records. And we're simply saying that by doing that, BOP has shown that they are capable of processing individual records requests faster than they are currently doing. And we would just like to, get evidence.
Is the way that they've fast-tracked those medical records requests, isn't it by cutting back on the Privacy Act exemption?
I think that's right.
They're not going to process it through FOIA at all, right?
I think by regulation, they technically have to process it through FOIA. I think my understanding is that they're just doing it different levels of less rigorous layers of review for the particular records, which enables them to produce them faster. And I think a lot of that has to do with the interaction with the Privacy Act.
What are the material facts that you cannot supply that you need, but you need to conduct discovery to get?
Yeah, so we would want facts into this channeling policy decision that they've made, sort of their analysis of how they're able to allocate resources in a way that allows them to process these particular individual requests faster than others. We would want discovery into their declaration talks a lot about improvements that they've made through centralization and training. We would want discovery into exactly how that's affecting the backlog and how that's going to help sort of my client get records faster in the future. And we would also want discovery into their assertions about their resource constraints.
In a nutshell, is the idea that you wanted to get evidence indicating that they're capable of complying with the time limits? Is that the whole idea?
Yes, we would want evidence to support our argument that they are capable of
And
complying.
did the district judge say you don't need that evidence, or was it solely on the basis of you haven't shown bad faith?
Our understanding is that the district judge said that we haven't shown bad faith. And so even though, I mean, I think
You're not entitled to discover.
correct. And I think the district court recognized that, this discovery would give us more information into these various aspects, but because we haven't shown agency bad faith, we're not entitled to it.
The irony is that everything you seek in discovery could be turned over under FOIA.
I think that's right. I mean, again, we would then be forced to wait for months or years to get that. So, we don't think that's a viable
And
alternative.
as I understand your position, it is that this bad faith idea, which you cannot get out of Rule 56D, you can read it till you're blue in the face and you won't find it. And it's not anything that is, so far as I understand, anything that's required in any other area other than FOIA, but it only applies to searches. It doesn't apply to a policy type lawsuit.
That's correct. This court's never applied it to a policy or practice claim. And it's only applied it in the inadequate search context and also in the inadequate exemption context.
I suppose that's another way of saying in every FOIA case.
Every FOIA case that this court's just talked about the discovery obligations. Yes, that's correct. But again,
I have just one
Yeah.
question about this. I think you might have some sort of good fairness arguments, but I was concerned. It seemed to me that in your brief to the district court, it sparked my curiosity. The district court didn't address an argument that it should be some standard other than bad faith for discovery. And in your brief below, it seemed that you accepted that standard, and the district court said you concede that the bad faith standard applies. Is that, can you address that? It suggests that you've waived this argument.
Yeah, I mean, I think we were sort of going off of what BOP's argument was. I don't know that we, contested it so much, but I think our main point in the district court was that whatever the standard is, in this kind of context where you have evidence of sort of a specific policy or practice, you should get discovery. We've looked at that and we don't think that the bad faith requirements should apply sort of in this narrow type of context where you have an agency that is violating the statute persistently. And the only question is, how are you going to remedy that? In that sort of context, we think discovery is
So
appropriate.
you're acknowledging that if this case concerned only a single delayed FOIA request, that you would not be entitled to discovery?
If we only had one request, then we may not be able to show that that BOP has a policy. Is that?
Well, no, I'm partly probing the basis of your making a distinction between entitlement to discovery in an individual case and entitlement to discovery in a policy or practice case. And so if you had the same situation of delay, but an individual case, I just want to get what the ground rules are. From your perspective, you would not be entitled to discovery.
I think we would be entitled to discovery depending on sort of the nature of the violation and how the discovery whether it could satisfy the normal requirements of 56D.
You have to explain more what you're thinking. I don't follow what that means.
Okay.
More concretely.
Sure. So in our case, we think because there's this persistent pattern of violations, we think that we should get discovery and BOP is not sort of entitled to this presumption of good faith that it harbors in the inadequate search context. In the case of an individual violation,
Pattern tends to show lack of good faith, or because it's somehow differently or not relevant, or?
Yeah, so I mean, our understanding of this sort of bad faith requirement, and again, I do want to emphasize that this isn't really in the rules or anything. This is something that the court's developed, and our understanding is that this is really grounded in sort of the normal presumption of regularity that the government gets in all sorts of contexts. And that presumption doesn't really apply here because the agency is already violating the timing mandates over and over again. In the other context, the agency is presumptively complying with the statute by, conducting the search or invoking an exemption. And the only question is whether the affidavit, confirms that. So there's no discovery necessary.
So back to the way you're characterizing the violation. Basically, you're saying that it's been shown that the Bureau can process prisoner information requests more quickly because it's doing that for medical records. But isn't it the case that the Bureau, under the Privacy Act, has promulgated regulations saying that the prisoners are not entitled, that the people aren't entitled to the very records that you're seeking?
My understanding of the Privacy Act regulations is that they just say that you're not automatically entitled to them. You still have to go through FOIA to obtain them. And so the only question is, once you're in the realm of filing a FOIA request, how quickly can BOP process it, and whether, it can comply with the statutory requirements.
So your fundamental argument is they're processing one category of documents quickly, and they should process ours quickly too. But it seems like the question should be, is there anything that suggests that your request should be prioritized over all the others in the FOIA queue? And can you point to anything that would suggest that? I mean, it seems like any FOIA requester would come in and say, you're doing those fast, you should do mine fast too. Why should yours skip the line?
I don't know that it's necessarily skipping the line. I think it's just more of a streamlined process, as I understand it, because BOP still says that it has this first in, first out policy for all FOIA requests. Our understanding is that for certain individual records, they just don't go through the same, multiple layers of FOIA attorney.
It's actually, I could be wrong, but I think the setup is quite clear, and it's all based on regulations. The Privacy Act, there's an exemption. And then a separate regulation says all, even individual records, will be processed through FOIA. Now they've posted a notice that withdraws that Privacy Act exemption for one specific category exemption. So your claim would make sense if you had sort of a legal argument that it was arbitrary and capricious just to have that one type of exemption. Or maybe if you had initiated a petition for rulemaking. But this is fundamentally, you're asking us to invalidate regulations and order them to expand a Privacy Act exemption or to expand their multi-track processing regulations, which they also have authority to do and which are in place. But that's just not the way this case has been litigated. And it seems like I guess I'm concerned that it's a collateral attack on promulgated regulations, and you haven't sort of mounted a direct attack.
Yeah,
regulations.
I understand the point. My submission is that the regulations themselves really aren't, legally problematic. The problem is whenever you have these FOIA statutory requirements, the regulations prohibit the agency from complying with them. So to the extent that the violation is or to the extent we need to identify a legal violation, it's the agency's failure to comply with FOIA, and the fact that
So the analogy that you're drawing between the medical records and the other prisoner records seems to me to run aground on the shoals that Judge Garcia has just identified, that basically you're asking us to invalidate the extent to which the Privacy Act regulations continue to apply to the non-medical prisoner records. And that just seems to me to be not a FOIA claim, but a Privacy Act claim in FOIA clothing. And it feels very indirect, and it isn't contending, as Judge Garcia's question is indicating, with whether that choice to leave the Privacy Act regulation intact with respect to non-medical individual records is in any way ungrounded or unlawful.
Yeah, so I mean, in the Judicial Watch case, for example, the court pointed out that the agency conduct can be formal or informal, and so we don't think, for example, if the agency had a policy of selectively choosing which individual records, if it codified that policy in some regulation, we don't know that that would really change the analysis. And we don't think that the agency should be able to sort of abuse their ability to promulgate regulations in a way that allows them to escape FOIA's timing requirements. So, all of this is to say that I do think that it's the interaction of these regulations with FOIA's timing mandates that is creating the problem. And so that's why we brought this case under FOIA, because it's FOIA that imposes these requirements.
So if the case were to proceed to discovery, what additional information about the Bureau's FOIA processing do you think you'd be entitled to, and what would be dispositive of the policy practice claim?
So we would want information about their decision to selectively streamline certain individual records requests, how they're able to allocate their resources to accommodate that, and whether they're able to allocate resources to accommodate other streamlining for other individual records. We would want discovery into, like I said earlier, their claimed improvements, their centralization, and their training. We would want to understand exactly how that's helping them achieve any sort of progress with respect to the backlog. And we would also want to understand exactly how how the resources are allocated and you know, what is going on in the agency that I mean, you know, and I'll point to an example in the affidavit. It shows that their FOIA staff has dropped tremendously in recent years. We would want to understand exactly what's going on with that and whether the Bureau is just shifting resources away from FOIA to other parts of the agency, or, you know, how is it that this, you know, that the resources are being allocated?
Can I
The
also
only
ask?
thing that you would be entitled to in discovery is what's set forth in the affidavit on page 135 to 136 of the appendix. And that's Rule 56D says that the scope of the affidavit defines the scope of the discovery, and the district court has control of it.
That's correct. Yes, I mean, we think our affidavit, you know, it is broad
One
and
paragraph of that affidavit, right?
that's correct. And we think it's broad enough to sort of encapsulate everything that I've,
It's fairly broad,
yes.
which is why I said the district court can control the scope and cabin, the amount of discovery, but can't do that under Rule 26. This is Rule 56D discovery, and it's different.
That's correct. And we think, you know, to the extent there are concerns about the breadth or anything, we would, you know, be happy to work with the government on targeted discovery, you know, just focusing on certain documents, certain areas. And, you know, this isn't unusual. I can point, I mean, Judge McFadden had a similar case right after this court decided judicial watch, where he denied a motion for summary judgment based on an affidavit very similar to this one. And then the parties proceeded to some very targeted discovery about the agency's budget, about the agency's streamlining processes. And that ultimately resulted in a settlement, which, you know, would be a possible outcome in this case as well.
If the case were to proceed to sort of a final injunctive order, what would you envision that looking like? Is it just sort of an injunction to make best efforts to come into compliance with the 20-day time limit and then the promptness requirement, something else?
Yeah, I mean, I don't want to evade the question. Some of that will depend on what we are able to obtain in discovery. So, you know, to the extent BOP wants to try to, you know, explain to the court why it can't perfectly comply with the 20-day rule, you know, we would think that the court could take that into account and sort of its equitable decision and issue an injunction that requires BOP to adjust its policies as best it can to comply with FOIA's mandates. And again, you know, the specifics of that would depend on the information we're able to get in discovery about, you know, what's going on in BOP.
And my earlier question was, what standard do we judge their explanation against? And if we assume they had shown in good faith, we're trying to make determinations within 20 days, and we're trying to make prompt productions, but here's the challenges we face. And that explanation all held together. Is that sufficient? Is that the question we're supposed to ask about their explanation?
Yeah, I mean, my understanding from the explanation language, and this isn't really fleshed out in the judicial watch case as to what would constitute that. I mean, my understanding is that it would be a test that asks, are they doing it as fast as possible? And is there anything they can do to process the requests faster? You know, or alternatively, are they employing sort of unnecessary policies that are increasing the delays and, you know, causing greater statutory noncompliance?
That test, are they doing it as fast as possible? I have to say, I do not relish the judge who would have to manage applying that test. I mean, it just seems so intrusive of the agency's operations. And I understand where you're coming from, but it just seems like you're going to swing the door wide open to a lot of judicial supervision of FOIA processes. And I'm just not sure the courts are going to be up to that and be able to do that in a consistent way if the standard you just articulated is all the guidance that you can provide.
Yeah, I mean, you know, I do think that the courts are sort of applying this standard in the exceptional circumstances context with respect to individual records requests. They are able to sort of look at the agency's affidavits and sort of in those cases, what they'll do is they'll establish a timeline based on their understanding of the agency's processes. And you know, oftentimes the courts will evaluate the agency policies and look to see whether they're necessary and whether the agency can overcome them.
But the exceptional circumstances is sort of geared toward one request in a context that is accepted to be sort of stable, whereas you're saying, can they rejigger their process to deal with us faster? Whereas the agency has to think about its entire FOIA load. So it's, again, this gets back to a question that one of my colleagues was asking about is, how is it that you're not asking for queue jumping? And then we'll just have sort of whack-a-mole cases. Oh, now you want to be at the head of the line. No, you do. No, you do. No, you do. And so I take I mean, previously when I asked you a related question, you said, well, here it's different because we have a more specific shortcoming that we're identifying. And I guess I'd like to hear again your articulation of, you know, the policy that you're challenging. It's, I take it is not just that there's a failure to meet a widespread ongoing failure to meet the statutory deadlines. It's something more. Can you?
Yeah, so it's their decision to selectively streamline certain individual records requests that they want and not, you know, streamlining others. And therefore, for those other ones, they are violating FOIA's statutory deadlines.
And when you say streamline, what do you mean? Because sometimes you use the term expedited, which has, to me, this sort of queue jumping quality. What are they doing now that is inadequately streamlined? And to the extent that you know, what are they doing with the medical records that would equal, and why would that equally apply to these other records?
Yeah, and I think this is something, again, we would want to explore this in discovery to figure out exactly how they're able, but the delta between sort of the processing time for individual medical records requests and non-medical records requests is so large. We would just want to understand exactly how they're able to process those medical records faster and why that faster processing time shouldn't also apply to our individual records requests for non-medical records.
And the medical records, they don't have content that has to be removed in order for them to be released?
I think they do, it'll be, they'll have to go through certain protocols for redactions. Again, this is, something that we would want to explore in discovery, the extent to which they need to review for redactions and other types of information. And the extent.
You've been making those requests, so you're familiar with that process too, right?
Yes.
The medical records request. And on the other records, are you familiar with any of those records that have been produced? I mean, we can ask the Bureau of this also, but are there different kinds of redactions, more categories of redactions?
Yeah, my understanding is that in some of the disciplinary ones, there may be other sort of redactions in terms of other inmates that, may have privacy issues. But again, it's just something that this hasn't really been fleshed out. And so we would want, more.
And the
more
medical records, I had understood from your brief that they were being produced under the Privacy Act. Is that wrong?
Yeah, my understanding is that they still have to go through FOIA, and this is something, maybe I'm misunderstanding, and this is something that's sort of changed over the course of this litigation. So, to the extent that the court wants to remand for the Bureau to actually explain it, my understanding is that all of the records requests by attorneys still have to go through this FOIA process. They just have sort of a separate sort of streamlined track for these individual medical records requests.
So when your briefing talks about part of the problem is they're being channeled under FOIA and they should be taken out of FOIA processing, are you amending that here and saying, no, what we're seeking is FOIA processing, it's just FOIA processing more like the medical records?
Yeah, I'm happy to clarify that here. I think our position is that whenever we say they're processing through FOIA, they're processing them through the single FOIA pipeline that also applies to these, large systemic records requests. And, often that means that an inmate's personal record requests will just get behind these large requests and result in delays of months or years. We just don't know, and we our position is that that's not necessary, and we would want to explore that in discovery and figure out exactly how the Bureau can amend its policies to comply with FOIA.
Just one last question on the
Sure.
legal test. To use the words as fast as possible, and I understand why. I think that's language in Judicial Watch, but if we were just approaching this fresh, I think you would want a test that's drawn from the words in the actual statute. And when I read the statute, the timeliness requirement for production, not the determination, production is prompt unless there's exceptional circumstances. So a reasonable way to do this would be to ask if they're not doing it promptly, which you've alleged, Have they shown exceptional circumstances? And why wouldn't that be the statutory framework for this kind of claim?
Yeah, I mean,
Maybe you still win.
yeah, we would be happy with that. I mean, I think Judicial Watch does have a lot of language that says the question is whether the agency's adjusted its policies to make prompt determinations or to make prompt productions following its determinations.
Just didn't have to reach this question, right? It was
Correct.
past pleading, and this case is, what is the statutory standard for judging the agency's explanation?
That's right. And you know, we would be happy with the standard that says, you know, the agency has to have policies that result in prompt production. And if not, it needs to satisfy the exceptional circumstances requirement. Again, they haven't tried to satisfy that here, so we don't think, you know, that should be a reason for affirming or anything. But
So my understanding is that the Bureau does differentiate between, you know, simple, medium, and complex, and it has different queues, and then it processes those first in, first out. And so to some extent, it sounds like your claim is a challenge to the notion that these prisoner files should be processed under the complex queue. Is that accurate?
I mean, you know, they do have sort of this dual track where they have simple processing. You know, that doesn't constitute very much of the records requests. It's normally, you know, agency documents that are already online, and it certainly doesn't accommodate any requests from institutions themselves. That's sort of all lumped into the complex pipeline, and all of my clients' requests have been deemed complex, whether they're individual records requests or more systemic. So, you know, they do have this alternative track. We don't know that the denomination should really, you know, matter that much. Even if it's processed in a complex track, we do still think that you know, the question is whether they're able to comply with FOIA. And here we think that they are in certain circumstances.
That's helpful. But so would it be fair that you're wanting a simple track that's available to these records? One way of thinking about it conceptually is that I think the simple processing track should be possibly expanded.
Yes, I mean, we think they should have sort of a streamlined track for certain individual records, and if that's sort of through their simple track, then that would be fine. Depending on, you know, how they apply their simple track and how that works internally. But again, you know, the real question for us is just whether, however they're denominating the practice, or however they're denominating the request, are they complying with FOIA's mandates?
So I gather that the Bureau has a process for allowing an inmate to access their central file, and there's a footnote in the brief about 28 CFR 513.40, and that they can actually go and look at it electronically, or they can request copies of that file. And is that file one that encompasses medical, disciplinary, and educational information?
The central file will encompass some of that. I think there's a separate provision for medical records, but both of those provisions are just allowing the inmate to access them. And I think, you know, there's several problems with it. The first one is that it's under supervision from BOP. You know, it's a lot of it's in discretion of BOP. So, for example, if BOP doesn't want to give certain medical records that have subjective opinions of their medical professionals, they can withhold them and require the prisoner to file a FOIA request. So, you know, it's not really like a satisfactory process itself, and it certainly wouldn't apply to my client.
File a FOIA request, presumably the same limitations, Privacy Act limitations would apply. I guess I'm having trouble. I mean, there's a procedural difference between Privacy Act and FOIA, but substantively, the thing that troubles me is it seems like there are substantive decisions, substantive regulations, substantive exemptions under the Privacy Act that presumably would equally apply under FOIA. But in some of your articulations, it seems like you're arguing against that. It's really a substantive argument, no?
I mean, I don't know if this is responsive. I mean, our understanding is that for the inmates accessing their own records, there are just certain limitations that the Bureau puts on them. And, you know, and a lot of these are sort of more onerous than what FOIA would require. And so what happens is, yes, so for example, the Bureau can sort of limit the scope of the documents that the inmate is able to view. And they have a lot of discretion in that regard. They have to make a request. And you know, if you think about this in the context of an inmate trying to file a civil rights claim against the prison, I mean, it's tough to to imagine that the prison is going to, in their discretion, make sure that the prisoner is able to view all of their documents, let alone keep them and then give them to their attorney.
This wasn't brief, but I thought I saw in the regulations that one way a prisoner can get access is by reviewing it under the supervision of a BOP staff member, but that they also can request photocopy.
I think they can request photocopies. I mean, this also isn't in the record, but we have sort of in our, we mentioned the USP Thompson investigation that my client did a lot of work on. And in that context, we had instances of BOP staff sort of confiscating files from prisoners' cells. And so, that even though they're able to get copies, it really wasn't a satisfactory.
And are their
basis.
counsel not able to get copies?
So the council, if the council wants to get copies, then they would need to go through the FOIA process under 28 CFR 513.63.
28 CFR 513,
0.63.
and that's FOIA or Privacy Act?
That's FOIA, and its requests by attorneys on behalf of inmates will be treated as inmate requests for their own records under FOIA.
But there's a Privacy Act, or maybe it was a FOIA regulation that says the prisoner can get its own.
Correct.
photocopies.
Yeah, that's right.
Privacy Act.
My understanding is it's a FOIA.
Okay.
Yeah.
Okay.
But but for my client, it's the attorneys, and they do have to go through the FOIA process. All right. If there are no further questions, I'll wait for rebuttal. Thank you.
Morning, Mr. Plum.
Good morning. Good morning, and may it please the court. Thomas Pullum for the Bureau of Prisons. As this court explained in Judicial Watch, the rule in this circuit is that an agency's compliance with FOIA depends on its good faith effort and due diligence in administering FOIA, and that therefore not all agency delay or other failure to comply with FOIA's procedural requirements will warrant judicial intervention. The uncontroverted evidence offered by the Bureau establishes the agency's good faith and due diligence, and that the agency's inability to process all requests within the statutory timelines does not reflect an abuse of FOIA's statutory scheme or a total disregard of the agency's obligations. On the contrary, the Bureau provided a reasonable explanation for its processing practices and outlined many efforts it has made to improve its processing times. For this reason, the district court properly granted summary judgment on the policy and practice claim to the Bureau. And because the agency's showing was sufficient to warrant summary judgment, and the lawyers committee did not offer any evidence of agency bad faith or evidence that would otherwise undermine the agency's showing, the district court did not abuse its discretion in denying discovery. And I'd like to start by responding to kind of two issues that were raised by counsel for the lawyers committee. One goes to the nature of the process for access to the medical records of adults in custody. Counsel described it as a streamlined FOIA processing, but that's not what it is. This process is described in the Federal Register 89, Federal Register 49906. And I think the way that Judges Pillard and Garcia described it is correct, is how we understand it, that what the agency was doing there is saying that we will waive an exemption under the Privacy Act, where doing so is consistent with the Bureau's correctional interests, and allow access under the Privacy Act, where records are not exempt under the Privacy Act. An individual has a statutory right to gain access to records about that individual, and they are not processed under FOIA. So this is not a streamlined FOIA processing. It's not a kind of a FOIA light. It's processing under the Privacy Act. So that was one point. The second point is I would just like to confirm our understanding. This was a point raised, I believe, by Judge Garcia, that the plaintiff in the district court did advocate for the same standard regarding discovery that we have said applies here. This is at JA 114 and 115. First, they said an agency may satisfy its burden on summary judgment on the basis of affidavits if they're reasonably specific, and if they're not called into question by contrary evidence in the record or evidence of bad faith. That's the general FOIA standard for summary judgment. And then further down on J115, they acknowledge that discovery in FOIA cases is rare and is permitted when the court is, quote, assured that an agency's declarations are reasonably detailed, submitted in good faith, and the court is satisfied that no factual dispute remains, quoting Baker and Hostetler versus Department of Commerce. And that is a FOIA case involving the kind of mine run FOIA case, as counsel describes it, not a policy and practice claim. So they specifically quoted standard FOIA standards for summary judgment and discovery. The district court applied them, and that's why we think there was no abuse of discretion. And I'm happy to take any questions that the court has.
Can I ask you my question about the legal test? So you've proceeded as if delays are justified or at least, don't warrant relief if the agency is acting in good faith to address the backlog. And my concern is the statute doesn't say that. The statute does say if there are exceptional circumstances and you're exercising due diligence, then a court won't order production immediately. And I'm struggling to understand why that wouldn't be the test. We would ask, even in a pattern or practice case, has the agency come forward that in a way that shows we are facing exceptional circumstances and are exercising due diligence, not just the latter?
Yeah, so I think the court answered this question in Judicial Watch when it said, in language I pointed to in my introduction, that it's long established in this circuit that an agency's compliance with FOIA depends on its good faith effort and due diligence.
Here's the big problem with that language. It's quoting Open America, which was decades before the 1996 revisions to the exceptional circumstances definition. And at that time, courts had generally treated the exceptional circumstances exception exactly the way you're saying. And Congress stepped in and said, if you're dealing with a predictable agency backlog, you have to show you're making reasonable progress towards addressing that backlog. And that's just what's missing. That's the only thing that's missing from what Judicial Watch, which didn't have to address this question. The only holding there is there was an unexplained delay, gets you just past a motion to dismiss. And so why that was quoting from the pre-1996 exceptional circumstances formulation. And I would just say, why not use the actual statutory standard now?
Well, I don't think it was necessarily quoting from the standard. It was from the statute. It was saying that it agreed with how Open America had applied this, and this court has generally applied FOIA cases, just that good faith and due diligence are the touchstones underlying the scheme generally, is what Judicial Watch said. But if I could just make one additional point, which is that even if you wanted to look at the exceptional circumstances test, we think that would be satisfied here because the agency's declaration establishes that it is making reasonable progress in reducing the backlog of its requests, which starts with kind of stopping the bleeding, which is what the agency is trying to do through all of these.
What about the staffing issue? I mean, the context here isn't, it's certainly seemingly commendable efforts are being made, but the fundamental reality is that it seems like the number of annual requests is going down, backlog is still going up. And the primary cause seems to be that your staffing levels are decreased dramatically. And we don't have an explanation of why that is or any efforts you've made to increase staffing levels or.
So I think there's, I would like to push back on the idea that the kind of only reason behind the backlog is staffing levels. Mr. Boehm pointed to the increasing number of complex requests, so that even if the number of requests is slightly trending downwards. The number of complex requests, which take more time, is trending upwards, and that the agency went through a very difficult time during the pandemic where there were competing demands placed on FOIA staff, including things like helping to provide vaccine cards to prisoners, providing information to family members about the status and health of their relatives who were in custody, and providing medical records on an expedited basis through the informal process that was later formalized under the Privacy Act to allow lawyers to request home confinement or compassionate release. But even so, turning to the staffing, I mean, what the declaration notes that there was a general decrease in staffing levels for a time. I think it would be inconsistent with the presumption of regularity to assume that that was because the agency was selectively firing FOIA people and doing other things. And we've pointed in our brief to evidence that
it would have to be nefarious. It's just you're not prioritizing FOIA responses. Maybe a statute with a promptness requirement and an exceptional circumstances requirement requires you to.
Well, of course, I mean, the Bureau has to comply with many statutes, and how the Bureau allocates resources from kind of a lump sum appropriation would be, in the Bureau's discretion. But we pointed to evidence in our brief that the court can take judicial notice of, that the Bureau is actively trying to hire people for specifically FOIA provisions. We pointed to postings for 5 different positions that were open at the time that we submitted the brief. So that's just really inconsistent with, even if the court could entertain, the speculation that the Bureau was acting in this way.
I guess there's a little bit of a mismatch though, or a kind of a black box in the Bureau's declaration, given the more focused, I mean, if the claim were just a general delay claim, I could see the policy and practice of delay. I could see the Bureau's affidavit being quite responsive. It's commendable that there are separate tracks. It's commendable that the Bureau has created this more streamlined approach for certain of the Privacy Act releasable documents, so they're not all left with the only access being a FOIA effort. But what the Lawyers Committee has argued here is that there's this cognate group of records, and they may be wrong that they're analogous, but they're saying that they're analogous. The disciplinary and educational records that are part of a prisoner's file, just as the medical information is part of a prisoner's file. And one of the questions is, well, why are the disciplinary and educational records classified as complex? And we don't have an answer for that.
So I appreciate the opportunity to address this. What the Bureau has said is that requests for records that come from an individual institution, as opposed to kind of the main Bureau, will generally be on the complex track. The fact that there is this Privacy Act alternative for medical records has no bearing on the classification of a FOIA request as simple or complex. This is a totally separate procedure. And as I think some of Your Honor's questions indicated, I don't think it's really coherent to argue that the agency is engaged in a policy or practice of violating FOIA because it fails to make other processes outside of FOIA available for certain categories of requests. What the Bureau did was look at its Privacy Act exemption and said that, generally we will be able to waive it for these categories of records because it won't be, that won't compromise our correctional institute interests. And so those will be available under the Privacy Act. Now, of course, just because requests for records are generally records from individual records from an institution are generally on the complex track. Doesn't mean they will always be. It depends how broad the request is. And there are certain types of records that can be more easily released. So if a request is narrowed to focus on those, the Bureau can actually move the request to the simple track. We cited some, I believe, a Bureau program statement in our brief that talks about the components of central file, and that there is a kind of releasable section of the central file that includes certain categories of records. So it really depends on what's being
Can you give us
requested.
a little bit more sense of what that might typically look like? What might be in that?
I apologize, I don't have the program statement with me. If you hold on 1 minute, I can tell you the agency's kind of general practice when, so as part of its kind of continuing efforts to improve FOIA processing, the agency has a kind of general practice now when it gets these requests for individual records, and they inform the requester that they can place the request on the simple track if it's narrowed to certain types of records. And the types of records that are often identified are medical records, mental health records, admissions or releases history, recidivism risk assessments, progress report or program review, work history, drug program history, custody classification, disciplinary history. These are all kind of identified by code.
Where is that?
I mean, that's not in the record. I'm just describing what
Is that a public document?
no, this is just what the agency is doing as a general practice now. This is all just to make the point that it kind of depends on, as in any FOIA context, there's often a dialogue between the agency and the requester to try and get things narrowed and sped up as much as
I think
possible.
one of the items that you read just now from the program statement is disciplinary history. Is that right?
For a certain category of records, and I apologize, I just don't know what's involved there. But I don't think that we need to get into this level of detail, because on our reading of Judicial Watch, what the agency needs to do is establish its good faith effort and due diligence in responding to requests, and we think that the agency's declaration amply does that.
If due diligence, I mean, just to push back on that a little bit, if due diligence and the reasonable progress that Congress, explicated in amending the act after Open America, if due diligence includes, in response to a policy or practice claim, showing that the agency is being diligent more systemically in the way that it's treating categories of records, then it seems relevant. I mean, I'm listening to what you just read and I'm thinking, well, that kind of information might have made for a more persuasive declaration on the Bureau's part in response to the policy or practice claim that the channeling of one subset of individual record information has been very smooth and streamlined, and other aspects of individual records information not. Do you have an explanation for that? I mean, that seems to me that's the thing that their claim is seeking a reasonable response to. And I'm not sure that the declaration
Well, I think
file really
so.
speaks to that.
The Lawyers Committee on Appeal certainly focuses on this channeling argument. That was not the evident focus of the complaint. It was not the evident focus of the briefing in the district court. The complaint is really about just meeting the timelines. And so the declaration was responsive to the complaint, and it explained the agency's processing practices. It explained some of the challenges the agencies faced, including the high number of complex requests, the competing demands on staff. It demonstrated that the agency, in fact, meets the statutory timeline for requests on the simple track. The agency explained that BOP FOIA professionals process both more FOIA requests overall than the DOJ average, and that they do more complex requests than the DOJ average. So that, I think is good evidence of due diligence and good faith effort. It also explained the agency's efforts to improve by implementing a robust training program that uses modules developed by the Office of Information Policy, which is kind of DOJ's expert on FOIA. And it said that the Bureau constantly reviews its performance and statistics to look for efforts to ways to improve. And that one of these was this centralization light improvement that's described in the declaration. And Mr. Boehm explained that this resulted in 36% more requests being processed on a weekly basis. That is a concrete improvement right there and quantified. And when you put, the declaration also mentioned the kind of informal practice that was developed during the pandemic of providing expedited access to medical records to facilitate these requests for compassionate release and home confinement. The Bureau formalized and broadened that in the Federal Register notice that we pointed to, that this court can take judicial notice of. And I think it's just important to look at all of these efforts. None of this is controverted, and none of this resembles the facts of the only other case where this court has recognized a policy and practice claim, which is pain, and nor does it meet the kind of the descriptive language that the court used in Judicial Watch and other cases. And if I could just highlight some of that language, Crew 2 referred to rare instances of agency delinquency. Payne described the situation there as a persistent refusal to end a practice for which the agency offers no justification. And Judicial Watch described policy and practice claims as involving abuse of the FOIA scheme, delinquent or recalcitrant conduct, a total disregard of FOIA's requirements. So I don't think in any way does what we have here in the declaration line up with how this court has described the scope of policy and practice claims.
I do want to emphasize that what you pointed to in the Boehm Declaration, many of those efforts, they're exactly, I think, what the sort of systemic due diligence is responsive to that. But I'm not sure that I checked because I wondered about the point that you're making about whether it was clear in the district court that they were really focusing on the sort of, for want of a better shorthand, the channeling point. And I thought they did make that clear.
It's mentioned in a page and a half, to be sure, but I'd also just like to look at what they mean by channeling. I mean, there is a regulation that has not been challenged that says that agency requests are processed under law, and that means the Privacy Act or FOIA. There is a Privacy Act exemption that has been waived in part, but it's a general exemption for individual prisoner records. And so what that means is that requests by regulation go through FOIA. And I think the argument that a failure to create sufficient processes outside of FOIA, that's just not an argument that the Bureau has a policy and practice of violating FOIA itself. And it boils down to the contention that if an agency can't meet the statutory deadlines, then it can't take advantage of FOIA's exemptions and must simply disclose documents through some other process. I am not aware of any case that provides authority for this proposition.
So I had a question that really helpfully highlights, which is under do the substantive, like when you roll back, for example, the prerogative that the Bureau has not to release medical records under the Privacy Act, you say, we are going to release those medical records. What is the sort of are there provisions within the Privacy Act that mirror or are analogous to under FOIA the exemptions such that certain information that would disclose someone else's privacy interest or, law enforcement practices or deliberative process that are taken out of something that's released under the Privacy Act?
So my understanding of the way the Privacy Act works is that the Act contains certain exemptions that an agency can take advantage of through rulemaking. as the Bureau has done. The Bureau's exemption is set forth in regulation, and that the Privacy Act, this is subsection T, and the interface of these statutes, by the way, is described in OIP guidance that is publicly available. It's called OIP guidance, the interface between FOIA and the Privacy Act. This guidance explains that under subsection T of the Privacy Act, agencies can't rely on FOIA exemptions to withhold records to which individuals have access under the Privacy Act. So when you submit a Privacy Act request and there's no applicable exemption under the Privacy Act, you can't apply FOIA exemptions. There may be some, my understanding is there could be some redactions for information that's about other people because the Privacy Act gives you information about your own records, but that it's not the same kind of intensive review for multiple exemptions that FOIA has, which is, I think, in large part why the Privacy Act access under this formalized process can operate so much more quickly because we don't have to have multiple experts looking through the documents, doing a painstaking review. We've cited cases where district courts have held that these central files are often parts or sometimes in whole exempt under FOIA. Exemption 7F is one that's been relied on. So, you know, these are requests that take a long time because they're difficult. These files are thousands of pages long. Even just the medical files that can be requested through the Privacy Act, those can be thousands of pages long because people may be in prison for a long time. People have a lot of issues in prison. There's a lot of, you know, their whole life is in prison. So there's a lot of things to have records about. So it's not like there's kind of 1 or 2 pages when you request these. There can be thousands that have to be reviewed.
Mr. Pullum, just to step back, if it seems like in one respect, you want us to think about the case as follows. I just want to make sure I understand. You're seizing on the fact that BOP withdrew the Privacy Act exemption a little bit to effectively argue BOP needs to process more records under the Privacy Act, but they've offered no legal basis for explaining why that would be. Right, okay. And then—
That's right. There's no Privacy Act claim or claim under any other source of law that would require that process.
And if this case were about BOP improperly designating their requests as complex as opposed to simple, we would have expected to see some argument about what goes into making something complex or simple and what the nature of their request is, but that's absent from the complaint.
That's right. And there's no claim that
And
BOP
that's why it's not
selectively
declaration.
designates their claims as complex, but allows other, there are a lot of lawyers that make requests for these. There are public defenders, you know, all around the country. We don't hear other groups, you know, making these same claims, and they have not alleged any specific unfavorable treatment here. So that's right.
You quoted page 115 of the joint appendix a while ago. And is it your contention now that the plaintiffs here waived any claim that they're not required to show bad faith in order to get discovered?
I just meant to show that they had advocated for the exact standard that we set out in our brief, which—
At one point, but you never made that argument in your brief, did you?
No, we did not point specifically to.
Why shouldn't we say that you'd waived it? Because you didn't make it in your brief.
To the extent that you could say we waived a forfeiture argument. I just think it's relevant to demonstrate that it was common ground in district court, and I think underscores the reasonableness of our argument that discovery on these claims is judged by the general standard that applies in all FOIA claims. So I think it's just relevant to underscoring the reasonableness of that argument. And this court in, for example, Judicial Watch applied, now that case didn't involve discovery, but it borrowed other general FOIA standards and said they apply in policy and practice claims. So I don't think there's been any kind of special carving out for this nature of claim.
Thanks very much.
Thank you. We ask that the judgment be affirmed.
Mr. Stafford have time? We used up the time on direct, but you can have a couple minutes of rebuttal. If you have rebuttal, you don't need to use it.
Thank you, Your Honor. I'll just make a few quick points. The first point I want to make is that whether the individual medical records requests are subject to a streamlined FOIA process or a separate Privacy Act waived exemption, in our view, this really doesn't matter. The critical point is that the agency has demonstrated a capability of processing certain individual records requests within the FOIA time limits. And our view is that the agency should have to explain why other individual records requests aren't shouldn't also receive the same treatment. At a minimum, we think that this shows that we should get discovery. And a lot of the arguments from my friend on the other side about the Privacy Act, you really won't find them in the BAME declaration. You won't find a lot of the sort of nuances and the difficulties that they're now saying that they face with these Privacy Act or certain types of medical records. None of that's really explored in the declaration. And I think, the fact that we're now reading from internal agency documents that we've never seen about how the agency's, looking at classifying certain individual records as simple. We think that also shows that we should, at a minimum, get discovery. With respect to that, I do want to highlight that that has not been my client's experience. The Lawyers Committee, we've sent dozens and dozens of requests for individual records, and not once have they ever been classified as simple. So, to the extent the agency has this internal decisional framework for classification, it's just not been our experience that it's been applied here. And finally, I just want to emphasize that if you affirm here, our main concern is that this is really just going to result in persistent noncompliance and forcing us to file over and over again the individual suits under 552A 6C. And we just don't think that Judicial Watch requires that. Judicial Watch specifically says that FOIA requires agencies to improve their record management systems to enable prompt responses without routine judicial involvement. And so we just don't think that the other side has a viable rule. And so we'd ask that you reverse.
Thank you.
Thank you.
Case is submitted.
Case number 23-7175. KLEO AG, a stock corporation formed under the laws of the Principality of Liechtenstein, appellant, versus Rivada Networks, Inc., a Delaware limited liability company. Mr. Parker for the appellant, Mr. Babood for the appellee.
Morning, Mr. Parker. You may proceed when you're ready.
Thank you. Good morning, and may it please the court. David Parker of Hunt & Andrews Kurth. I'm here representing the plaintiff appellant, KLEO AG. Now, this case concerns defamatory remarks that attacked KLEO's business reputation as a satellite service provider. The alleged falsity of those remarks is not at issue here on appeal. Rather, the sole issue is whether KLEO adequately alleged injury from those remarks, and KLEO did so in two independent ways. First, KLEO adequately pled defamation per se, meaning the statements are inherently damaging based on their nature. And second, KLEO adequately pled special damages as well, which is just actual injury from those statements. Now, the district court held that KLEO didn't adequately plead either path to injury, and that was error. It also had important ramifications that go beyond this case. I'll start with defamation per se.
Before you get going, if we were to rule for you on the question of special damages, would there be any reason to still reach the issue of defamation per se?
I don't think you would have to, Your Honor. I think that would be enough for the claim to go forward and to reverse the judgment of the district court.
It would be enough for the claim to go forward. I'm imagining then you go back and are unable as a matter of proof to establish special damages, then would you have lost the appeal of defamation per se, or would you have a preserved second appeal?
That's a good point, Your Honor. Now that we're talking about it, I think you actually should rule on the defamation per se, because that allows us a different category of damages, which are presumed damages. So I do think even if you rule in our favor on the special damages question, you should also rule on the defamation per se question.
Oh, we wouldn't have to.
I don't think you would have to. You could, I guess, well, I don't know. I think you might actually have to, because I think it does affect the case. So I'll start with defamation per se, which means that basically the statements are inherently damaging. The law recognizes 4 specific categories of statements that are defamatory per se. And one of those categories is that the statement attacks a plaintiff's fitness for trade or business. And that's because such statements inherently deter others from transacting with the party. And here, Rivada's statements fit into that category for 2 reasons. First, some of the statements conveyed that KLEO had lost its frequency licenses. Now, these frequency licenses are absolutely critical to KLEO's business. KLEO operates a satellite network that uses radio frequencies to communicate with Earth. KLEO cannot use those frequencies without a license. And as a German court recently put it, losing these licenses would, quote, destroy the existence of KLEO. So the restatement speaks to this pretty directly, and the restatement has been adopted by the DC High Court. And what it says is that, a statement does attack a plaintiff's fitness for trade or business if it accuses the plaintiff of lacking a, quote, peculiar skill or ability that is, quote, necessary for business or trade. And that's been borne out in the case law as well. As we explained in the briefs there.
The question is, does it attack fitness for trade or business if they're just saying they had lost one set of frequency licenses and they aren't disabled from seeking more? There's no categorical bar. This particular thing of value apparently had been purchased by Tryon. And I'm sorry, that Rivada had purchased an ownership interest in Tryon, and Tryon terminated the frequency usage agreement with KLEO. So it's a one transaction, not an overall kind of disbarment or delicensure.
Yeah, so I think at this stage of the case, we have to, the court has to accept the allegations in the complaint. And what we alleged is that losing these licenses would, again, quote, destroy the existence of KLEO. And that was actually a court that said that. So whether, if Rivada wants to, in discovery, try to prove that, KLEO could have reapplied for these licenses, that's something that it would be entitled to do.
The concern would be to destroy the business. Seems kind of conclusory. Why? Is this the only frequency right available? There's no possibility of securing different frequency rights or getting these back?
Right. So, I don't think that information is in the complaint or in the record at this stage. Right. So, but what we have alleged is that, this would destroy the existence of KLEO. Again, that's a court saying that, and Rivada hasn't contested that. Rivada hasn't.
Why would it destroy the existence of KLEO?
Because KLEO needs radio frequencies to communicate, for satellites to communicate with Earth. And it's lost those particular frequencies that it had. And according to Rivada, that is, and according to Rivada now has those frequencies. So what we have in the complaint is
KLEO unable, right. If somebody goes out and says that attorney is losing his bar license, that's a defamation per se because it suggests he's done something wrong, right? If you say a business lost a contract, that suggests they lost a contract. It happens all the time. They can go get another one. They're now going to have litigation. Doesn't necessarily impugn the character of the business.
Yeah, so what I would say to that, Judge Garcia, is I agree with you that a case of a professional is maybe a little bit different. But I don't think this case is more akin to losing just one contract because KLEO needs these licenses to do any amount of
Needs the
business.
licenses, but the question is, if it lost the licenses, is that because of incompetence or criminal action or what?
Right, and I'm glad you asked that, Judge Randolph, because I don't think that there has to be some suggestion that KLEO did something, criminal or horribly wrong to lose the licenses. If you look at the restatement, what it actually says is one example of challenging, fitness for trade or business is a merchant that is insolvent. And so that kind of allegation doesn't necessarily, suggest that the merchant did anything horribly wrong. Maybe the merchant's clients just didn't pay him or something like that.
Let me ask about that. I mean, I've considered this, and it seems like that's why the kind of allegations that you said are not in the complaint would be important. If this complaint said KLEO was created for the one and only purpose of securing these frequency rights, and the investors will totally abandon us if we do not have these frequency rights, something like that, to make this KLEO lost its license tantamount to saying KLEO's going bankrupt.
So if you,
There's those kinds of, that context in this specialized kind of situation is just absent from the complaint, isn't it?
Sure. So I have a few responses to that, Judge Garcia. My first is that I actually do think there is some additional information in the complaint that goes to this. And that's that you have the allegation that satellite manufacturers approached KLEO and then refused to do business with KLEO. And then we have 3 other relationships that were allegedly lost as a result of this as well. So I think all of that kind of supports the German court statement that this would destroy the existence of KLEO and deter anyone from yes, Judge Billard.
So those were the allegations that you're relying on also for the special damages.
That's correct.
And it struck me that, I don't know this business, but the use of the term partner, satellite manufacturers heard this and they refused to partner with KLEO. What does that mean? What was the partnership before, and what was the injury in terms of the partnership loss?
Yeah, so I think, a fair inference from the complaint is that what we mean by partnership is that the satellite manufacturers are going to enter into a contract with KLEO to help build satellites that KLEO needs to send up into orbit. And we did allege specific money damages that we suffered as a result of losing the relationships with those manufacturers. We even quantified this.
Basically, apparently traveling to hold a business meeting or some effort to reach out, but it's hard to say what the delta is between the satellite manufacturer's willingness before and after. So it's just, there's nothing alleged about we were on the brink of entering a contract or we had a contract. Satellite manufacturers were eager to work with KLEO and were making better and better bids. And then after this, nobody would talk to us. We don't have any allegations that actually support or do we have any allegations that actually support the notion that there's a before and after scenario that's different?
I do think there is some of that in the complaint. We did allege in the complaint that prior to these defamatory statements, KLEO was succeeding quite well in its plan of establishing its satellite network.
Very vague. Succeeding in what ways?
It had launched multiple satellites, Your Honor. It had passed certain regulatory milestones. All that's detailed in our complaint. But the before and after, I think, is that before the statements, KLEO was succeeding. It did have investors, and there's actually allegations of how much money we had raised by that point. We did have satellite manufacturers working with us. If we were sending satellites up into space, I think that's a fair inference. So I
It would
think
have been so much more crisp, though, to say, well, we worked with satellite manufacturer X and Y and expected to continue to work with them. And when we circled back after the conference and after these defamatory statements, they said, we're not really interested in doing that anymore. And it's not inconsistent with what you've alleged, but boy, is it not spelled out.
so. I certainly agree that, there could be more detail on this issue alleged, but I think the question is whether there is enough in the complaint right now to go forward. And I think that there is based on the case
Is
law.
it your proposition that the loss of an important business asset impugns the integrity and the competence of the business itself?
So I think it depends on what the asset is. And in this case, it's a
Depends on
license.
what the asset is?
Yes, I think if it's an asset that would literally prevent the party from doing its business, like a license in this case, I do think that rises to the level of defamation per se. And as to whether it impugns,
What authority do you have for that? Statements like this float around constantly in all kinds of contexts, speeches and conversations and so on and so forth. I think back about, well, I'm not going to get into the various companies and everything else. I could give you a dozen examples. So the licensing cases fall into the category of a situation where the person can't operate their business because it's a unique business, like being a doctor or being a lawyer. If you lose that license, then you're not competent to be able to practice anymore. But a business that loses a major asset can still survive or try to survive by getting more assets or getting more capital or, whatever else is necessary. So the case, I don't see those cases, those lawyer cases and the doctor cases having anything whatever to do with this case.
Yes, Judge Randolph. So I think that, again, what matters in this case is the importance of these particular licenses to KLEO. And, I think without these licenses, KLEO has a satellite network that is essentially just worthless. And so, I acknowledge it's not exactly the same as the case of a professional. Those are the closest cases that we could find. But I do think it's similar in that KLEO cannot operate its business just as a lawyer or a doctor could not legally practice their business without a license.
Well, it's like a lawyer or a doctor losing their office, not their license.
I'm sorry, losing their office?
Yeah.
Well, I think they could still practice law, though.
Let me ask you about the China. That was the other prong of the defamation per se, right?
Yes.
The comments about China. And why is doing business with China a defamation?
So I don't think it's just doing business with China. I think the accusations were that KLEO was a quote unquote front organization. And the implication was that they had deceived European regulators. They had set up essentially a European shell company to obtain these licenses under the pretext of using those for the benefit of Europe.
Borders on criminal conduct. Is that the idea?
I don't know if it has to be criminal conduct, but it's certainly
Illegal.
dishonest in business.
Yeah. But doesn't that depend on the law of Liechtenstein? And we don't know what the law of Liechtenstein is.
Right, and to be clear, we have not alleged that it would be illegal in that case for KLEO to request the licenses.
Well, illegal or in violation of whatever regulations Liechtenstein has.
Correct.
We haven't alleged that either.
We have not. No, I think really the crux of this is the dishonesty in business, and also the threat that if these licenses are transferred to China or the control of the networks is transferred to China, that the Chinese government could take over the project. I think those are kind of the two elements of that.
So are you saying that so Ganley refers to some very strict rules with regard to moving or de facto moving constellation rights from one place to another? And then, as you mentioned, refers to KLEO intending to have a sort of front organization in Germany, while actual control of the satellites would be with China. And I take it to you to be saying, in response to Judge Randolph's question, that it actually doesn't matter whether there are very strict rules concerning moving constellation rights, but that his statement makes it sound to the average listener that there is a violation of very strict rules about foreign control that KLEO has committed.
Yes, Judge Pillard, I think that's a very good point. And I think that with respect to that point, it would not matter whether this was actually illegal if what Rivada is communicating is that it would be illegal.
And wouldn't it have to be such that, I mean, if somebody says, oh, you gave her the bigger piece of cake, that's illegal under the Equal Protection Clause or something. And it would have to be that a reasonable listener in the position of the people that KLEO thinks are the audience for this defamation would credit Ganley's statement that this is deeply unethical or maybe illegal, maybe even criminal. But I guess my question is, if there's this insider crowd at the satellite convention, wouldn't they know the content of any such rules? And how likely, if it's, I mean, I'm just probing whether it matters that you haven't actually told us what the real rules are
Right.
on transfer. Because if there were real rules that prevented this transfer, it seems like it's easier for you to show defamation per se.
Yeah, no, I think that's a good point, Judge Pillard. And again, this is not a theory that we focused on necessarily below. We were more focused on the dishonesty piece of this and the fact that, you know, if it's going to be taken over by China, that the Chinese government could step in and take over the project. But I do think, you know, that it would be fair to rule on this record on this illegality point, if your honors thought that was compelling as well.
What was the result of I mean, you mentioned this German court, and I saw that sprinkled in the papers here. What was that all about?
So there have been multiple litigations and arbitrations abroad concerning Rivada's, you know, attempted illegal takeover of KLEO. So that's been challenged in multiple foreign tribunals. And as we explained in the complaint, you know, we've already received some, you know, positive preliminary rulings, some preliminary, you know, the equivalent of a preliminary injunction restoring our people to the board. So that's what those are about. And that German court, you know, in the course of explaining this dispute, was reiterating how important these licenses are to KLEO by saying they would literally destroy the existence.
Was it KLEO that sued Rivada?
So there are multiple, I think there are maybe even 3 different foreign litigations and arbitrations happening.
Is that because KLEO in fact lost its licenses?
Well, no. So we definitely dispute that. And as we said, we've actually gotten some positive rulings in those foreign tribunals that we did not ever lose the licenses because.
That's a matter that's being litigated?
Yes, that's correct. And certainly at the time of, right, because we're talking about the time of Rivada's statements. So, you know, I think there's an argument that later the Liechtenstein authorities did terminate KLEO's licenses when they issued the order, but that was after the statements. And what Rivada was saying is that at the time of those statements, KLEO had lost its licenses.
But why doesn't that May 20th order from the Liechtenstein authorities, you know, defeat any, you know, causation argument? I suspect that's going to be one of the things Rivada says.
It could argue that, Your Honor. I mean, I think that there's a time period between the statements and then that May, you know, whatever it was, order. And during that time, KLEO lost a lot of relationships. KLEO had to expend a lot of money to get those relationships back or to attempt to.
But doesn't the Liechtenstein order go to the effectiveness of conduct that happened before, that you were during the period of the statements disputing? But it's kind of a nunc-pro-tunc point, right? That Liechtenstein rules actually did effectively get the licenses.
So right, I guess that would be, if Rivada were to try to use that, I think that would be an argument that the statements weren't false, right? That KLEO actually did lose their licenses and that was confirmed by the Liechtenstein order later. That is not an issue on appeal though. They have not argued that as an alternative ground for affirmance. The district court assumed that the statements were true. So again, the only issue here on appeal is damages and injury. So with respect to the first defamatory message, yes, Your Honor.
Statements were true? You mean assume that the statements were false?
Yes, I'm sorry, assume the statements were false. Yes, exactly. So with respect to the first defamatory message, it was per se about lacking the licenses. The restatement speaks pretty directly to this. It says that accusing someone of lacking a peculiar skill or ability that is, quote, necessary for trade or business is defamatory per se. And then we do have the cases in our briefing discussing professionals that lost their licenses. Now, KLEO doesn't dispute.
You said that goes to truth or falsity, but haven't you pointed to Liechtenstein stripping the rights as in part evidence of damage?
Yes, Your Honor. So that is one of the 4 relationships that we say that we lost and that we say satisfies special damages.
But that one has to now fall away?
I don't think that one has to fall away, no. I mean, Rivada's picked on that one because I think they think it's our weakest case for causation, which I would agree with out of the 4. But I don't think it has to fall away because, you know, because of the language in the order, and I think they may even use that as a demonstrative later. But, just because the Liechtenstein authorities didn't say in their order, we heard Rivada statements and that's why we're doing this, doesn't necessarily mean that we haven't proved causation. But really, that is the
causation for the claim that you focused on, which is the loss of manufacturer relationships, right?
correct. That's what we think is our strongest case of special
Right.
damages and causation, and we only need one to go forward.
So it occurs to me that if this category of damages is 4,000 euros of travel expenses, you don't say when that occurred. If those were incurred in June, after the Liechtenstein order comes out, then that could seem like some kind of an intervening cause that cuts off a chain of causation. If it happened before May 10th, then we would say it's irrelevant.
Right. So
Do we know the answer to that question?
we don't have a specific date on that. I think it's a fair and reasonable inference from the complaint that it would have been before May. I mean, KLEO losing,
Scrambling to keep
keep the
things
business alive. Exactly.
and you would have stopped after
Right.
Liechtenstein's order.
Yeah, I think it would be a lot harder to get
Okay.
satellite manufacturers after that order came out. Exactly. And so again, with respect to the second message that was defamatory per se about KLEO being a front organization, I mean, that really conveys two different things. That KLEO isn't really a real company, it's just a shell company. And also that KLEO had lied to regulators and others by pretending to be a European company, pretending to get this license on behalf of a European company. And again, the restatement, which has been adopted by DC, says statements challenging someone's quote, honesty in business are defamatory per se. And the district court itself actually acknowledged this. It said that the statements accused KLEO of fraud and deception. And I should also say that with respect to the first defamatory message about lacking the licenses, I think the district court acknowledged that as well by saying these statements challenged, KLEO's viability. So I think the district court really made findings that supported and necessitated a ruling of defamation per se, but then didn't actually go through with ruling that. So I'd like to turn now to special damages, and this is the second independent ground for reversal of the district court. The special damages are not actually that special. They're really just actual damages from the defamatory statements, and they must be pled and proven in any defamation case where there's not defamation per se. So I think that makes this issue in particular important to other courts. And what Rule 9G says is that these damages must be specifically stated, and this court has interpreted that to require two things. First, that the plaintiff described the nature of the losses. The district court held that we satisfied that element. Rivada doesn't dispute that on appeal. So really the heart of the dispute is causation and the way in which the special damages resulted. And we've touched on that already. I think we had 4 different relationships that we said we lost in the complaint. As I said earlier, I think our allegations about the satellite manufacturers are the strongest. And what we alleged there was that within several days of Rivada's statements, multiple satellite manufacturers approached KLEO and expressed concerns that KLEO was going to fail or was likely to fail, and then they refused to partner with KLEO. So they were essentially repeating back the bottom line message that Rivada had just conveyed about KLEO, failing or being likely to fail because of the loss of these licenses. I think that's a pretty close causal link to have in a complaint. I think it's more than enough to establish plausibility in this case, and it's more than this court has, more than the allegations in other cases that this court has held to be sufficient, as we've explained in our brief.
Wasn't the Tryon vote to shift the licenses away from KLEO before the challenge statements? And isn't that something that disrupts the alleged causal relationship to any of the damaged relationships that you've identified among your 4 sources of special damages?
Yes, I'm glad you raised that, Judge Pillard, because that I think is an error that the district court made. So, what the district court held, I think this was in a footnote, was that, there's the allegations would support a reasonable inference that these earlier actions of Tryon, et cetera, are what caused the satellite manufacturers to have concerns and not Rivada's defamatory statements. And what I would say is that is certainly possible. That's a theory that Rivada could prove on appeal. But at this stage of the case, we're on the pleadings, and the court has to draw all reasonable inferences in our favor. And so if there's a reasonable inference that Rivada's statements caused these damages, but there's also a reasonable inference that Rivada's earlier illegal, what we say is illegal conduct caused that, I think that inference has to be drawn in favor of us at this stage. And the district court also drew reasonable inferences against KLEO when it reasoned that it wasn't clear when these manufacturers approached KLEO. So what the court said was, I see that Rivada made these statements on the second day of this 4-day conference. I see that the manufacturers allegedly approached KLEO during the same conference, but essentially it's possible that the manufacturers approached KLEO on the first day of the conference, which would have been before Rivada's statements. And I think this is really a classic example where the court should have drawn a reasonable inference in favor of KLEO. If you look at the complaint, the entire thrust of the complaint is describing the impact of the statements at that specific convention. It says, quote, the immediate impacts were felt there. The quote, purpose and result of the statements was to discredit KLEO there. Even the paragraph that discusses the manufacturers, approaching KLEO with concern starts with after the defamatory statements. So I think the court absolutely should have drawn a reasonable inference in favor of KLEO. And that footnote where it says, I think there's a reasonable inference the other way, I think is particularly concerning to leave out there. Now, Rivada doesn't really challenge this, which I think is also telling. They don't defend the district court's reasoning. They don't say it's unclear from the complaint when the manufacturers approached KLEO. And so I think they don't defend it because it's extremely difficult to defend.
All right, we've given you a lot of extra time. We've taken up a lot of time with our questions. So if you could wrap it up.
Yes, thank you. I'll wrap it up really quickly. So the second mistake, I think, was the district court, I think, effectively raised the burden for alleging causation on the pleadings, which should be plausibility, but the district court effectively held that even that close temporal link was not enough. And I think, if that ruling stands, other district courts may be encouraged to similarly raise the burden from plausibility at this stage. So with that, I'd like to respectfully ask that you reverse the judgment of the district court and allow KLEO to pursue the discovery.
Your Honors, on behalf of the appellee, Rivada Networks, my name is Dariush Behbood. And before jumping in, Your Honors, let me just say that it is an absolute honor and privilege to be here. This is my first argument before this court. It's an absolute honor. Thank you so much for hearing me today. Now, Your Honors, before I jump in, I will address defamation per se and the special damages going in the same order as my friend, Mr. Parker. However, before getting into that, Your Honor, Judge Pillard, I want to specifically address first the question that you asked my friend, Mr. Parker. Your Honors, I think this court does need to resolve the defamation per se point because, in the alternative, as I think you were suggesting, Judge Pillard, we go back down to the trial court, file another motion to dismiss, or even go through trial. They end up losing, and then have they preserved the defamation per se argument? We come all the way back here again and start another appeal. So I do think the court has to resolve the defamation per se point as well. Now, I also want to specifically address a couple of points that Judge Pillard and Judge Garcia that you mentioned regarding the per se point. KLEO can obtain other licenses. Now, it's not specifically alleged, or they didn't specifically allege, as you pointed out, I think, Judge Garcia, there's only one license. In fact, they actually specifically said the opposite. In paragraph 14, Your Honor, they say radio frequencies used by satellites are a limited and valuable resource. So KLEO itself is admitting that there are frequency licenses that can be obtained. Now, regarding defamation per se, Your Honors, as we know, they have to concern extreme subjects like criminal behavior, or as relevant in this case, person's suitability for their chosen profession. Now, as Mr. Parker argued here today, they allege that these statements are defamatory per se because they convey two messages. Number one, that KLEO lost the frequency licenses. and so they didn't have the legal ability to conduct their business. And then number two, the KLEO was planning to move its network to China. But first, Your Honor, there's a couple of points that I would like to make in regards to the licenses. So in its briefing and in here today, they state that Rivada's statements falsely convey that KLEO lacked the legal ability to conduct its business. However, Your Honor, it's really important to look at the complaint because that is, after all, what they're confined to on this motion to dismiss. If we look at pages 111 to 114 of the joint appendix, KLEO alleges that in regards to the statements concerning these licenses, which are statements 2, 5, and 6, Your Honors, the statements, KLEO alleges, merely discredited KLEO in the eyes of the satellite community by giving the false impression that KLEO's rights to commercialize the relevant frequencies, and this is the important part, Your Honors, were more attenuated or uncertain than they actually were. Close quote. So, Your Honor, nowhere does KLEO allege that these statements convey, as it now argues in its appellate briefing, and as it argued here today, that KLEO lacks the legal ability to conduct its business.
Well, this is on a pleading, a motion on the pleadings. And at the same time that KLEO is claiming that it's suffering this defamation, it's also contesting whether it lost its licenses. It's saying that, you know, the move by Rivada to get them was itself unlawful. So it seems like that might be an explanation for saying it's more attenuated, that its underlying position on the status of those licenses is that it still rightly owns them. So why isn't that just the explanation? And the statement is still defamatory because the statement is KLEO lost its licenses. That's the statement. It speaks for itself. And they're saying lacking the legal ability is like, they have no license. They got no legal basis.
Right. So, Your Honor, even if we assume that they did allege that, Your Honor, the key is we have to focus on what the word suitability and fitness even means. And I think all three of you, Your Honors, raised this point with my friend, Mr. Parker, is, you know, these licenses, well, let me back up for a second. Rivada's statements did not convey that KLEO lacked the license to be a satellite network provider, generally in the same way that an attorney needs a bar license or a doctor needs a medical license to practice law, like many of the cases that they cite to. And Judge Randolph, you made, I think, the crucial point here, which is when it comes to professional licenses, when you're talking about individuals like a dentist, a doctor, a lawyer, when that person receives that license, what is the medical board or the bar telling that doctor or license? They're telling that doctor, that lawyer, that they have the qualifications necessary, they have the skills and competence and abilities necessary to provide medical services, to provide legal services. These frequency licenses are not the same thing at all, Your Honor.
But they're also not the same thing as, you know, buying inventory that's widely available. I mean, if you're a franchisor that wants to set up a restaurant in a national park and you think you've won the bid, but somebody, you know, falsely says that you haven't, and therefore you have no prospect to run the business in the park, and so nobody will give you the equipment. I mean, so it's a rare asset, and it may not come around again.
Right. You know, so Your Honor, I'll go a step further than that. Let's say that Rivada alleged that KLEO did not have a satellite. Right? They're a satellite network provider. That is probably the most crucial asset for KLEO. So if Rivada had said, KLEO doesn't even have a satellite, Your Honor, as I think all of you have mentioned, that's just it's a crucial asset. It doesn't go to their skills or competence.
No, but it seems to actually make their point more than yours in the sense that there is a legal precondition to doing this business, which is that you have a license.
Right.
And everything else is, you know, the whole industry is eager to get a satellite network up and running. That the folks that are lucky enough to do it are the people that have the legal rights.
Right.
So seems like maybe you're right that we don't have a satellite. That you don't have you don't even have a satellite wouldn't be defamation per se. I'm not sure that establishes that saying you have no license.
Right.
Doesn't establish defamation per se.
Right, Your Honor. But I think, again, what we really have to focus on is what the word suitability and fitness really means. So
what about the front? You're just a front company. You're not a real company.
Right. So Your Honor, that's a really good point. And it's something that I wanted to specifically address. So regarding the front organization, in their briefing and here today, Mr. Parker argued that Declan Ganley, the CEO of Rivada, stated that KLEO was a front organization, but that's not actually what Rivada stated. If we turn to, Your Honors, I believe it is, so it's page 10 of the second amended complaint or joint appendix, page 108. What Rivada actually says, allegedly here, Your Honor, is it's the third paragraph down on page 108 of the joint appendix, Your Honor. Rivada allegedly says, these are European filings, and it was pretty obvious, not just obvious, but categorically stated that the plan was to move these to China. I'll focus on that specific portion of that statement a little bit later, Your Honor. Rivada continues, and while there would have been, if you like, a sort of front organization left in Germany, everything else would have been moved. So Rivada was not saying that KLEO is a front organization or was a front organization. It's a little bit more attenuated than that. What Rivada was saying is they're moving to China, categorically stated they're moving to China. Now, in their briefing, they allege that, or they argue that KLEO, that Rivada said there was a secret plan to move to China, but it's actually exact opposite. It was actually categorically stated. But just to focus again on the front organization, Rivada was just saying that there's a sort of front organization left in Germany. So what they're saying is, allegedly, KLEO is going to move to China, which there's nothing wrong with that. It doesn't go to suitability or fitness. And that what would be left in Germany is this sort of customer-facing company left. It doesn't really concern, it doesn't go to that extreme subjects that defamation per se is reserved for you.
Why is that? I'm not sure I followed that point.
Right, so again, it doesn't go to the suitability or fitness, Your Honor. It certainly doesn't go to solvency. And I'm not even really sure it goes to dishonesty. KLEO, I think, has done well in focusing on the word front, because you immediately think, oh my gosh, this is a fake company. But that's not where Rivada was actually saying there. Again, we're not saying that KLEO is a front organization. What he was saying is,
I think he meant Shell.
I'm sorry, Your Honor.
I think he meant Shell.
Right, but again, so even if we assume that's the case, I really don't think that goes to sort of dishonesty that the restatement is speaking of, that Mr. Parker refers to.
It's not like they're moving their company into the mafia.
Exactly, Your Honor, exactly. They're simply stating that.
We have United States companies in China,
Exactly, Your Honor, exactly.
countries from all over the world.
Exactly, Your Honor. I don't think it's any different than if Rivada had said that KLEO was planning to move to Russia or some other country. It just does not involve the sort of extreme subjects, dishonesty, or again, to go back to the suitability or fitness for your chosen profession, Your Honor.
So counsel, can I take you to the special damages and causation?
Absolutely, Your Honor.
KLEO realizes that its strongest claim is that the statements deprived it of potential business with other manufacturers. And just want to hear what your best response to that argument is.
Yeah, so Your Honor, there's a couple of points that I'd like to make in regards to that. So all KLEO has alleged, well, first of all, let me back up a little bit. As we know, KLEO had to satisfy the Rule 9G heightened pleading requirement. They have to connect the dots. They have to make that causation requirement. And I do think the manufacturer's
This is an interesting legal question. Are you submitting that the Rule 9G, it certainly requires damages to be specifically stated?
Yes, Your Honor.
Do you think, and why, does it impose a heightened pleading standard for causation? Or are we just using the Twombly-Iqbal standard, which is no slouch in the first place?
No, Your Honor. So it does apply to the causation standard. And if I could point the court to this court's Fowler decision, which we reference at page 24 of our brief, therein specifically, this court states where special damages must be alleged before a cause of action can be stated, the courts require a good deal of particularity, especially in the slander and libel cases. The complaint must set forth, and this is really going to the causation point. I think the first sentence also goes to it, but the complaint must set forth precisely in what way the special damages resulted from the spoken or written
Doesn't the
words.
Smith case say that as well?
I'm sorry, Your Honor?
Doesn't the Smith case say that as well?
Yes, it does, Your Honor. And I wanted to focus on the Fowler case in particular. And Judge Pillard, I understand that you authored the Smith case, but I wanted to focus on the Fowler decision in particular because of that first sentence that I just mentioned.
So when was Fowler decided?
That was decided in 1950, Your Honor. But still very good law. In other cases, of course, expanded upon that.
This sounds like it's saying you have to do something more than notice plead. We had a post-Twombly case saying, I could not find a case that addressed whether causation post-Twombly has to be established with more than what Twombly requires. And there's certainly a strong argument because as I think Judge Easterbrook points out in the Pippin case, Rule 9G does not say you have to plead special damages with particularity, the same way you have to plead fraud. It just says the damages have to be specifically stated, and that's just distinguishing from general damages. So
Yeah.
it doesn't necessarily carry a heightened burden on causation.
So I would respectfully disagree, Your Honor. I think the verbiage used in these cases stating that in order to satisfy Rule 9G, or even taking that out, in order to satisfy the causation requirement, in order to plead special damages, specifically stating that defamation plaintiffs have to establish the natural and direct result of defendant's conduct and how that resulted in the harms. I think that goes above just simple Iqbal, Twombly, or notice pleading standard, Your Honor.
Okay, so then let's go to what the actual allegations are, because it seems like the favorable reading of this complaint is we were proceeding apace. We had put satellites into orbit. Then on the second day of this big conference, Ganley says, we don't have our licenses. Over the next 2 days, manufacturers come and speak to us and express those same concerns, and now they won't work with us. Sort of very close in time, as your friend on the other side put it. And so what's specifically the gap in the causal chain?
Yes, Your Honor. So I'll address that by bringing up a point that Judge Pillard brought up, Your Honor. So I think the court below specifically addressed this, Your Honor. And so it states, citing this court's heading judge decision, that the court need not accept inferences drawn by the plaintiff if those inferences are not supported by the facts set out in the complaint. And at the joint appendix, page 108, footnote 3, on top of the court determining that shortly after is not enough to satisfy Rule 9G, the court also then goes to add on an additional layer as to why KLEO has not quite satisfied.
Yes, what is the point?
Exactly, Your Honor. So in their own complaint, they say that in the second half of 2021, so before the statements, Rivada launched a plan to take control of Treon's board by secretly purchasing ownership interests. Is that paragraph 27 of KLEO's complaint, page 105 of the joint appendix. And then on top of that, on March 2nd, 2022, so also before the March 22nd, 2022 statements, the Treon board then that Rivada attempted to install then declared the termination of the frequency usage agreement. So it cuts off, I believe is the verbiage that Judge Pillard used, cuts off that
Were there
causation.
allegations in the complaint that everyone in the industry knew that the newly installed Treon board had done that?
No, Your Honor, there isn't.
So I think in the drawing favorable inferences, right? The allegation is on let's say the biggest platform in this industry. He goes on the podcast, he makes the statement. The next day, everybody knows, and the next day, everyone expresses concerns. You have certainly a plausible counter argument, and you might get there after discovery, but it's hard to see why another plausible explanation that manufacturers had doubts because of the March 2 vote means it's implausible that it was also, at least in some measure, caused by the statements during the conference.
Right.
How would you bolster that?
Absolutely, Your Honor. So I think, so KLEO, first of all, KLEO had 3 attempts to try and establish this more perfectly. The court below provided KLEO with 3 attempts to get to causation, get to causation, get to causation. And as KLEO has alleged in their own complaint, this is a close-knit community. So presumably they could have easily stated, Your Honor, that, and they did not, that any of these individuals attended the conference, heard the statements, or even knew about the statements, or when they told KLEO we're leaving, and they have business relationships with these individuals, told KLEO, look, I heard the statements, I believe them, that's why we're leaving. But they haven't stated that at all. The best that KLEO has been able to come up with.
I thought they did allege that satellite manufacturers expressed out to them that they were concerned about this.
So what they do allege, Your Honor, is that during the conference,
Right.
they expressed this belief.
And so bracketing the district court saying, oh, we don't know whether it was before or after, this is, again, it's a complaint. We draw all inferences in favor of the plaintiff. It's much more of the conference went on afterwards. Their whole focus is on these defamatory statements. The fact that as a technical matter, they haven't said after the podcast, to me, I'm not going to rely on that as fatal under the pleading standard. So given that.
But Your Honor, I think it's important that when CLEO could allege that something was specifically after or shortly after, they did.
Okay, is
But-
that your best argument? You're hanging on that?
I think that's the best argument that we have, Your Honor. Because if it really was after, then they would have alleged that, especially after 3 attempts. So if something was specifically after or shortly after, and they could provide a specific date, they did so. But the best that they can come up with here is that during the conference this happened. But a second point, Your Honor, is there was no parroting, quote unquote, of the manufacturer's statements, Your Honor. So the manufacturer is claiming that CLEO is likely to fail. That could have very well come from before, as again, this is a close-knit community, before Treon terminated the usage agreement, which, as Mr. Parker stated himself, is absolutely crucial. So given that this is a close-knit community, I think it's also a reasonable inference that these manufacturers heard about this terminated frequency usage agreement, and that would absolutely mean that CLEO was going to fail or likely to fail. Simply stating that they're going to move to China, or again, saying that they're going to lose their licenses, which already happened after the Legislative Office of Communication made this determination, Your Honor, it's not enough here. I think the district court was correct in assuming that even giving CLEO all reasonable inferences, if here is 9G and they haven't sufficiently alleged 9G, they're over here. They haven't alleged enough to get past Rule 9G, Your Honors.
Let me ask you, Mr. Beboud, on the question about the accusation that CLEO intended to evade well-understood regulatory requirements by transferring control of the satellite constellation to China. Why isn't that enough to raise a question or to besmirch CLEO's honesty in business, which is a standard basis for defamation per se?
I'm sorry, Your Honor, can you say the first part again?
So the podcast, Ganley says, CLEO intends to evade well-understood regulatory requirements by transferring control of its satellites to China. And an accusation that someone plans to evade well-understood regulatory requirements would seem to me to question their honesty in business. And questioning a party's honesty in business is one of the categories of recognized defamation per se.
So I don't believe that's one of the categories of recognized defamation per se, Your Honor. So there are a couple of district court opinions from the 50s or 60s, and there is the restatement. But in trying to find circuit court opinions that specifically address this honesty in business, there is no such thing.
So you would say that our court should reject that as a category and say there might be circumstances in which some questioning of honesty might amount to defamation per se, but not this.
Not this, Your Honor. I think
Even though the restatement does identify it.
I think even though the restatement identifies this, Your Honor, the restatement is not controlling on this court. I think we have to look at what our circuit states, and there's nothing like that suggesting that this is the turning point. This is
So if someone were to say publicly that everyone knows that you're not honest in your legal practice, you would think, well, that's not defamation per se?
I think, so Your Honor, I think there's an important distinction to be made between corporations and individuals. So, saying that a lawyer is not honest, very much like I think it's the Ingber decision where the court determined where I believe the statements were either unprofessional, unethical. That goes to the suitability or fitness of one's chosen profession in that regard. But corporations stating that there's an intention to perhaps not follow these particular rules of Liechtenstein, I don't think that's enough, Your Honor.
Really? Here, they're basically, the point is that they're not following the rules and in fact, a front or shell corporation that is facilitating what, whether this is true as a matter of positive law or not, they're arguing that there's some ban on foreign control, and that this company is structuring its business, its whole only business project that we're aware of, in order to evade those and to give control to China at a time when many, regions of the world are feeling threatened by competition from China.
I just don't think it's enough, Your Honor. Given what our established precedent is, it has to go to the suitability or fitness for the chosen profession. I just don't think that gets to and meets what our established and well-established law is in this circuit, Your Honor. So if I may, Your Honor, there's just there's one last point that I would like to make in regards to special damages. And we submitted this to Your Honors via Circuit Rule 34I. On paragraph 45, KLEO references this May 20th, 2022 order from the Liechtenstein Office of Communication in its complaint, but doesn't attach it. So as part of our preparation, we submitted it to this court last week. And in this 9-page opinion, Your Honor, this decision from the Liechtenstein Office of Communication, nowhere does the Liechtenstein Office of Communication mention the DC conference, let alone Rivada's alleged statements that were made during the conference. There's not a single line, not a single word, not a single page that would indicate that this office, the Liechtenstein Office of Communication, was somehow influenced by, as the alleged paragraph 45.
That would show that the statements didn't affect the actual loss of license rights.
Exactly.
Do you think it's relevant to any other claim case?
I think it's particularly.
Clearly take the point.
Yeah.
Yeah. Okay. But sorry, I cut you off. You're not submitting that it's somehow relevant to another claim in the case. So
I think it's relevant in the sense that the Liechtenstein Office, only relevant in the sense that the Liechtenstein Office of Communication approved the transfer of the frequency rights. So again, to go to Judge Pillar's point, sort of cuts off the causation.
All right.
Thank you, Your Honors.
And did Mr. Parker have any, we'll give you a couple of minutes to make a rebuttal if you want it.
Yes. Thank you, Your Honors. I just have a few points to make in rebuttal here. So my friend on the other side said at one point that, all Rivada said was that there would be a front organization left in Germany. I mean, that the front organization is KLEO, according to that statement. What they're saying is KLEO is a front organization that's going to obtain these, move it to the real company, and then all that's left is KLEO holding nothing in Germany. Second thing is they say that honesty in business should not be a category of defamation per se, and that that's not been accepted in any circuit court. It has been accepted by the DC High Court, and this is an issue of substantive law where that's going to govern. That's the Ingber case, and it's at 1268. And it says the statements were, quote, clearly slander per se because they imputed a lack of honesty, character, or integrity. My next point is there was a question about whether Rule 9G imposes some heightened standard for causation. I think the answer to that, Judge Garcia, is no. It arguably imposes some specificity requirement for causation, but the ultimate threshold there is still plausibility. There's no case that says, you have to establish like by a preponderance or something like that on the complaint. And that would be kind of big news in light of Iqbal and Twombly.
So the specificity is about the amount of damages and the character of them. And are you saying that it's also specificity about causation, or just that once you've identified these are the damages we suffered, this is the amount incurred, what it relates to, and then the causation is Twombly? Or are you saying the causation is more like particularity under the fraud or mistake aspect?
Right. So, I mean, honestly, as I read Rule 9G just on its face, it seems to be talking just about the character of the damages. But this court, I think in the Smith versus Clinton case, said that it also relates to causation. But I think you have to read that, what this court was saying there in light of Twombly and Iqbal. I don't think the court was saying, I think at most what the court was saying is you have to allege specific facts to show causation. You can't just allege it in a conclusory manner when we're talking about special damages. But I don't think that actually raised the bar above plausibility.
So it's enough to just show correlation, not causation?
I mean, I think it has to,
January 1st, Mr. X said why. On January 30th, we lost money. That's enough. Huh?
I think it's a fact-dependent issue, right? And I think it depends on whether that gap in time, given all of the circumstances, allows a plausible inference of causation. So there might be circumstances where that gap in time wouldn't, but in this case, I think it does because it's only a few days and they're basically parroting back the bottom line of Rivada's message.
I mean, that kind of sequence is a classic form of circumstantial evidence of causation.
Yes, I would say so, Your Honor. Then my last point, I know I'm over my time, is just that, what my friend on the other side said was that it would certainly be a reasonable inference to say that, these concerns of the satellite manufacturers were caused by, Rivada's prior actions. And, the court said that as well. I think that's actually almost fatal to their case because if they're acknowledging that that's a reasonable inference, I think it's an even more reasonable inference that they got those concerns from a podcast that is directed towards the industry. It's a close-knit industry that's well aware of this type of media. I think that's an even more reasonable inference. And again, if you have reasonable inferences going both ways, you have to choose the one that supports us. So
Thank you.
Yes, thank you.
All right, the case is submitted.
Case number 24-1092. Energy Harbor LLC petitioner versus Federal Energy Regulatory Commission. Ms. Wu for the petitioner, Mr. Kennedy for the respondents, Mr. Suarez for intervener, PJM Interconnection LLC.
Morning, Ms. Wu. You may proceed when you're ready.
Good morning, Your Honor. May it please the court. My name is Pamela Wu. I'm with the law firm Morgan, Lewis & Bacchius, and I'm here on behalf of the petitioner, Energy Harbor LLC. I would like to reserve 2 minutes for rebuttal. Thank you. The heart of this dispute is whether it is just and reasonable for PJM to assess penalties on Energy Harbor for capacity that Energy Harbor had no obligation to provide and capacity that PJM had approved well in advance for it to be unavailable. The answer to that question is no. The tariff language is clear that the extent of a generator's unavailability due to an approved maintenance outage should not be included in the calculation of a performance shortfall. And that's what Section 10AD of Attachment DD of PJM's tariff provides. The 300 megawatts that were unavailable at SAMUS Unit 6 due to a maintenance outage, so the scheduled removal from service that PJM approved a month before the winter storm that led to the assessment of penalties.
Let me
Should
ask
have
you
been.
a preliminary question, Ms. Wu. Does the PJM system of assessing an energy resources capacity commitment depend on an understanding of its unforced capacity? In other words, is it the same kind of system that the New York ISO uses as described in Keyspan Ravenswood? You know what I'm talking about?
The uncommitted capacity and the overall maximum output of the facility is relevant when a facility is bid into the market. And so and this is the capacity market, and this is the market where PJM can approve and then subsequently commit generation to provide when called upon 3 years down the road. Once that capacity is cleared and committed into the market, the relevant portion is the committed portion of the capacity. And in Energy Harbor's case for the SAMUS facility was comprised of 3 generating units They were individual and separately operated, but they were bidden as a combined resource. It had a total maximum output of 1,490 megawatts.
So can I, on a normal day, the Samus plant would attempt to meet its expected performance by calling on any of that 1,490 megawatts, right?
That's correct. And that is because the way that the plant is operated is that of the 1,490, 1,036 was the actual committed capacity. That is the obligation that Energy Harbor had for the market, and that's what it was compensated for. And so when Energy Harbor operated the unit, it's now since been retired, it operated under the the goal of providing 1,036 to the market each
But I
year.
guess your yes answer to my question means that with a 300 megawatt planned outage, you could have met the expected performance during all the relevant performance intervals, correct?
That when you look at the resource, the facility as a whole, as an
As a
aggregate.
practical common sense.
Sure,
If you
yes.
didn't have another problem with the planned outage, you would have met the expected performance.
That's right. But the tariff provision that applies here is specific to the resource on which the capacity resource is based. And some of that,
If we put, and I appreciate, obviously we'll pay attention to the text. If we just step back, the fundamental question about your position is why? Why would PJM give you a credit if you could have met a credit based on your planned outage? If you could have met the expected performance?
sure, and in requesting an outage, submitting an outage ticket for the 300 megawatts that were going to be unavailable due to this maintenance that needed to be performed, PJM authorized that outage. And to us, the obligation to supply power is reduced by the amount that is taken offline and made unavailable due to the maintenance outage.
How is that consistent with the tariff amendment, which refers, or I guess it's the tariff which refers to, the tariff amendment only applies to the extent that a capacity resource is unavailable solely because of a maintenance outage. So once you have another outage, a forced outage, then it's no longer applicable because it's not solely because of the pre-approved maintenance.
Thank you. And I think the interpretation turns on how the word resource should be interpreted. And when we look at the language, the term resource should refer to the generating units individually.
But that's not what the way the capacity contract was written. It doesn't specify, there's not one for 6 and one for unit 7 and one for unit 8. It's for the aggregation. That seems like that should be dispositive.
Well,
Of that point, that they're not contracting for capacity from three different.
yes, and the contract is for the megawatts that are reflected by the resources. But when we go back to the language, though, the language is the resource on which the capacity resource is based was on a generator maintenance outage. And I think that's where the operational, the way the outages are submitted, requested and approved by PJM, I think that's where that informs and actually necessitates an interpretation that the resource should be at the generating level as opposed to the combined resource level.
So you said that because the outage is described, submitted, requested, the request for approved maintenance is described unit 6, that should be read into the tariff and should supervene the language of only to the extent that a capacity resource is unavailable solely because.
I think that the manner in which an outage ticket is reviewed and approved should be considered when interpreting this tariff provision. An outage ticket has to be submitted for each generating unit individually. Energy Harbor cannot submit an outage ticket that covers 2 units. So let's say Samus Unit 5 and Samus Unit 6 was requesting authorization to go out on a maintenance outage. Separate outage tickets would need to be submitted for SAMUS Unit 5, and a separate outage ticket would need to be requested for SAMUS Unit 6. And PJM is free to approve each or both.
Can I ask, why does, even if you were right about what a resource on which the capacity resource is based, if you were right about what that means, how does that help you? Because the text says, to the extent the capacity resource is unavailable. And if we just go back to my very first question, the capacity resource is the whole plant's megawatts.
That's
And
right.
they were, let's say, they were unavailable to the extent of 300 megawatts. And it seemed like PJM would say, yeah, that's exactly what we did. We didn't consider those. We knocked it off your installed capacity, and we did the calculation from there. It seems like it doesn't get you where you need to go.
And respectfully, when we consider the resource, the maintenance outage was specific to SAMUS Unit 6. It took off 300 megawatts from being available to the market. And so our interpretation of this tariff is that the resource on which the capacity resource is based, so SAMUS Unit 6, which is a resource that basically supports the SAMUS facility, that unit alone had one maintenance outage. There were no other outages in effect at the unit. And so when you look at the generating unit level, then the 300 megawatt exemption, excusal reduction should apply for the performance shortfall for the capacity resource as a whole.
I understand that argument. And the one other question I had was, seems like there's a, maybe you can help me with this, but it seems like there's a disconnect between where you started, which is arguments that may or may not be right about it's on being unfair or improper to look at installed capacity instead of committed capacity. But that might support an argument that they should start their calculation from installed capacity. That's not what you requested. You requested a full 300 megawatt deduction from the performance shortfall.
Yes.
Why do you get from?
Sure.
Yeah.
And thank you for that question. The performance shortfall calculation turns on the committed capacity. When we look at the inputs to the performance shortfall calculation, the expected performance is based off of the committed capacity. The actual performance is just how the unit performed. But the whole premise, the performance shortfall, and actually the capacity market as a whole, the purpose of the performance penalties is to ensure that resources show up when they are called upon 3 years down the road. And so
And that adequate maintenance is performed on them, that their
that's correct.
investments in the
That's correct.
infrastructure.
But that is to the committed portion of the capacity and not to the uncommitted portion of the capacity.
Well, you say that, except that I thought you acknowledged at the outset that the concept of unforced capacity applies here, basically that the recognition of the capacity to actually contract in a capacity market is assessed in light of the history of performance of that unit. In other words, a brand new spanking never failed unit would probably have a higher proportion of unforced capacity to total installed capacity. And an old, kind of rickety unit would have a lower sort of ceiling of unforced capacity compared to installed capacity. And so I understand, and it's compelling, your argument that the capacity resource, the amount that's actually contracted into the market is the responsibility, but it's really underwritten by the unused capacity, isn't it? The excess capacity.
Thank you. And I would still turn back to the fact that the performance shortfall and all of these calculations are all based off the committed capacity. This is the
But the
capacity.
committed capacity itself is based off of the
That's
installed
correct.
capacity.
But the obligation that Energy Harbor had to provide was for the committed capacity and not for the remainder. And to your point about aging units, this was an aging coal unit as well. And so once Energy Harbor received that capacity commitment for 1036, the way that it operated the units was we will operate at 1036, we'll staff it appropriately, we'll make sure that all the inputs are there in order to achieve the 1036 that was contracted for.
Great. Other questions? All right, thank you.
Thank you.
We'll hear from Mr. Kennedy.
Good morning, Your Honors. Robert Kennedy on behalf of the Commission. I guess I'll start with what I think is the key language of Section 10AD, which, as you pointed out, Judge Garcia, is the phrase solely because. The provision operates to provide an excuse for non-performance to the extent a capacity resource, which is defined as net megawatts from an existing facility, are unavailable solely because of a maintenance outage. And you see in paragraph 26 of the complaint order here, the Commission looked at it prospectively. Setting aside the 300 megawatts that were out of commission due to the maintenance outage, what did Energy Harbor have available to them when Winter Storm Elliott commenced and the performance assessment interval started? And if you just do the math, they had 1,190 megawatts available to them to satisfy their capacity commitments, which were just around 1,000 megawatts, and more than enough to meet the reduced expected performance levels, which were, I believe, 840 and 860 on the 2 days in question. So the Commission, looking at those numbers, said, given what you had available to you, you should have been.
The balancing ratio that you talked about, can you tell me what that is?
Sure. So it's a function, it's an input into calculating expected performance. And basically, as I conceptualize it, PJM will say, okay, here's your capacity commitment, your 1,000 megawatts that you contracted to provide, that we're paying you to provide. We're going to cut you a break. If the fleet as a whole is really only performing at 80% of its committed capacity, then we're only going to hold you to 80% of your capacity commitment when assessing penalties.
Is that also calculated in 5-minute intervals?
I think it is, but it's conceptually, it's a discount given to Energy Harbor based on the general performance of the fleet.
Everybody?
Yes.
All the generators?
Yeah.
Okay.
All the generators, and obviously in the PJM region. So again, the Commission looked at those numbers and said, given that what you had available to you, the shortfall couldn't be solely because of the maintenance outage. In their briefs, so that's prospectively. You can look at it the other way too. In their briefs, Energy Harbor attaches a lot of emphasis on the phrase that maintenance outage megawatts shall not be considered in the calculation of performance shortfall. So you can just look at the shortfall numbers and see that the forced outages more than eclipsed the shortfalls. On December 23rd, I believe the shortfalls range between 330 and 400 megawatts. Energy Harbor had a forced outage of 750 megawatts that entire day. And there's a similar story for December 24th, where the outages were between the shortfalls, were between 80 and 180. The forced outage rate started at 140, moved up to 375 around 9 a.m. And then from 11 to 11 at night, it was like 550.
I'm not sure I'm following the point you're making, just simply.
Simply, the amount of megawatts that were on forced outage more than captured the shortfalls. So you could draw.
Right, so as long as you're counting the forced outages first, they want to count the authorized maintenance outages first. And you are saying, no, you count the forced outages first. And that is the whole amount.
Well, right, you look at what they had available, and that's the end of the question. If they had enough, you don't even need to get into the forced outages. If they had enough available, then putting aside the maintenance outages, then necessarily those maintenance outage megawatts weren't the sole cause of any shortfall.
But that's because you're counting them afterwards. Whereas if their rule, you would reduce the
they view it, I'm sorry.
Committed capacity by that to start and just act like it's a smaller contract.
Well,
that's what I understand their position to be. And so that's why I ask it in terms of sequencing, which you count.
So what their position generally had been is the 300, it's just a credit, period. If there's a maintenance outage, you get a deduction from your performance shortfalls. And that doesn't work in this situation where there's dueling outages, because the tariff requires that the maintenance outage be the sole cause.
Right.
And here there's forced outages. The argument about installed capacity versus committed capacity, they have not really, there was some discussion of that today. They have never argued that you should do the math and start at committed capacity, subtract our maintenance outages and see how we performed. They've always just advocated for a straight credit of 300 megawatts.
Would it be?
But a credit on the,
Performance shortfall. A deduction from the performance shortfall.
Would it be a fiction? The capacity was 1490, from which the 300 was deducted. Right. So if you're going to avoid double counting, then the balancing ratio would have to be applied to 1490.
Well, the balancing ratio is just applied to your, it's not really double counting because it's just setting a level of expected performance. So you're just applying it to the committed capacity level. So they're getting the benefit. And maybe I should just step back and talk about committed capacity versus unforced, committed capacity versus installed capacity. And PJM will clear up the details if I have misstepped here. But as I understand it and as I conceptualize it, PJM in these markets, they're purchasing unforced capacity. And what that basically is a cap on the generators. What they can bid into the market is sort of capped at their installed capacity, their maximum generation, reduced by their historic outage rate. So PJM buys them at that level, but they are depending on the reason that level is set is because this is the most critical situations, a blizzard, high demand on a holiday weekend. You want them to be able to call upon that cushion that's available to them to perform when they're needed most. I mean, they've been paid all year to show up on this date. So you want them to be able to access that. And as you saw, they counted on the entire facility to meet their commitments.
and the reason that's correct is because that is the premise of the unforced capacity. And it's going to, am I right? I mean,
Yes,
I'm asking you this
right.
question. It's going to vary depending on the historic performance of a plant. And you might be willing to buy some capacity from an older, ricketier plant as long as it's got a bigger cushion
That's right.
behind it.
Yeah, it serves kind of, from PJM's perspective, it's a cushion that it can, it'll have this gap so that the generators can use to perform. It's also an incentive to the generators. If you're capped at bidding your unforced capacity, you want to reduce your outage rate so you can actually bid in more and make more money.
And are these plants, are they doing capacity contracting and they're also doing, same day real time?
Yes, so they're sort of two separate things. You get there's a capacity auction 3 years ahead of the commitment date. You get paid during the delivery year just for having received the capacity award. Then you bid into the energy markets and sort of getting how that relates to the unforced installed capacity. Which PJM references in their brief, there's a must offer requirement that you have to offer into the day-ahead energy market the installed capacity equivalent of your unforced capacity. So you have to go beyond your commitment, I guess basically multiplied by the historic. You have to, sorry, let me step back. You have to offer more than your committed capacity into the energy market every day to fulfill your commitments. And you can see that at 271 of the joint appendix. As for the argument that you should look at this at the resource level and apply it, I think that's contradicted both by the language of Section 10 AD and the record.
You mean 6, 7, and 8 when you talk about the resource level?
Yes, that as long as you have an outage at one unit, that's enough. So Section 10 AD focuses on the, the unavailability of the capacity resource, which is defined as the net megawatts of capacity from an existing facility. So that's essentially its maximum output, installed capacity. Then it directs you to look at the whether the unavailability of then it directs you to look at the resource on which the capacity resource is based. So how did Energy Harbor tell PJM that it was going to provide these net megawatts of capacity? And I think the record is undisputed, and I certainly, there's substantial evidence supporting the commission's conclusion that Energy Harbor treated this as a combined resource. You look at the layman affidavit, which they submitted in connection with their complaint, paragraphs 9 and 10, J 189, 190. They said, we entered into the market as a combined resource. It received an award as a combined resource. It had an obligation to perform as a combined resource. How did PJM treat it? You can see this in paragraph 64, I believe, footnote 64 of the commission's order. It recounts that PJM assigned a single resource identification number to the SAMIS units 5 through 7 when tracking performance throughout the Winter Storm Elliott. So everyone understood before this dispute arose that the resource that was supporting the capacity resource was the combined facility, and sort of accepting the analysis that Energy Harbor advocates for now, sort of, it really results in it's not symmetrical. Expected performance is measured on a combined basis. Actual performance is measured on a combined basis. So then if you just peel out and look at the maintenance outage on a resource by resource basis, it really gives the exemption an outsized influence on the math. And that's really contrary to the whole purpose of these revised rules, which are intended to restrict exemptions and put the risk of non-performance on the generators rather than the consumers.
Are you relying at all on any kind of deference?
So we do think that the commission is entitled to deference in interpreting, jurisdictional contracts. We think that that possibility survives Loper Bright. The court has recognized in the Kansas City's case, the National Fuel case that we cite in our briefs that predate Chevron, that the agency's expertise in dealing with jurisdictional contracts. I mean, the commission reviewed and approved this, particularly something as technical and in the weeds as the capacity markets and exceptions to capacity markets rules. Do you need deference? I don't think we do. I think we have the best reading, period. The only reading that gives effect to all the pertinent terms in the contract. So I don't think we need it in this case, but I think it is available to us. Any other questions? Thank you, Your Honors.
Thank you. Now we'll hear from Mr. Swears for PJM.
May it please the court, my name is Andrew Swears from the law firm of Wright and Talisman, representing the intervener, PJM. I guess I'll take the easiest question first. Judge Randolph, you asked whether or not PJM does this calculation for every 5-minute interval, and the answer is yes.
Yeah.
Um,
Not by hand, I trust.
Excuse me?
Not by hand.
Oh, no. No, in fact, if you look at the actual programming, which is in, I think it's in the petitioner's reply brief, you can see the actual programming that goes into the computer that calculates this. I think, well, let's start off with the generator ticket, which Ms. Wu talked about. And I believe she said that it takes 300 megawatts of capacity away from what's available to the market. I think the generator, if we just look, it's JA97, the outage ticket does not indicate what the committed capacity is. It says the ticket reduction is 300, installed capacity 600. So what is happening when a resource or a generator gives PJM requests a maintenance outage? What's happening is the available capacity to generate is reduced by that number. So here, their available capacity was 1490. It was reduced by 300 megawatts. That's the amount of the maintenance outage. And they clearly had more than enough megawatts available, even with that, as you recognize, Judge Garcia, that they could have met their capacity commitment. the capacity commitment is a commitment. They're paid a capacity payment every day of the year, even the days where they don't actually perform, in order to be available to stand by and provide those megawatts.
If a forced outage accounts for some but not all of a shortfall, then the shortfall can be partially excused by a maintenance outage or no?
If the forced outage counts for some but not all, I would say the answer to that question is yes.
That the maintenance outage could be,
The maintenance outage could be, again, to the extent that it is the sole reason for the outage.
for the remaining portion?
Right, right,
Okay.
right. And so,
If they hadn't failed, then they would have met their commitments.
If they hadn't had a forced outage, they would have met the commitments, notwithstanding the fact that they were
Correct.
on an
Right.
approved maintenance outage as well.
Absolutely, that's absolutely true. If there were not forced outages, they would have been able to supply that entire capacity commitment with the available generation.
And that, I mean, they make this, I think, intuitively very powerful argument that the only committed capacity is, only the committed capacity is what they're obligated for. And your position, I mean, we had discussion with both Ms. Wu and Mr. Kennedy about this, the notion that the entire installed capacity is really implicated in a capacity resource.
Your understanding, Judge Pillard, is exactly correct. When they bid into PJM, they are bidding in an amount of megawatts. That amount of megawatts is backed by physical generation. The distinction, and you pointed to the Keyspan Ravenswood case, Judge Tatel there did a very good job of explaining how you get from installed capacity to unforced capacity and why you need to do that. And it's because no piece of equipment is running perfectly 100% of the time.
But that's a different system operator. And so the citation for this, I take it, would be the 2024 FERC order that accepted PJM tariff revisions. I mean, that's in one place I saw it just publicly, that it's describes how the tariff entitles PJM to the complete physical capability. It's like, you didn't actually spell this out much in the briefing.
If you would like us to find the site, we could. It
That would be
wasn't
helpful.
implicated in the
That would be
briefing at
helpful
all,
because
so.
We're gonna have to write something.
Okay, we can.
And I think I'm persuaded that it is the routine operation and understanding of the parties, but.
Right, so in order to, supply any amount of megawatts to PJM, you have to back that by a physical resource. And when you tell PJM that you're going on a maintenance outage and PJM approves it, PJM is saying, okay, we recognize that your ability to generate megawatts is reduced by the amount of that reduction. The extent to which that implicates your capacity commitment is what's at issue here. And if it's the sole reason, that's one aspect of it. And then we need to see, well, to what extent does that reduction in installed capacity, the capability to generate, to what extent does that actually eat into your committed megawatts?
I think you were about to suggest that we don't even need to get into this intricacy of how you get from installed to committed capacity. And if you were, could you just explain why that is?
Well, the only reason why that issue, I think, comes up is because it is Energy Harbor's position that the calculation needs to start with the committed megawatts, and it is not relevant at all what the installed capacity is. And it is relevant, and that's why. I think that what's interesting about this case is so many of the facts are completely undisputed, right? There are clearly multiple outages affecting the Samus resource. The Samus resource bid in as an aggregate resource, as both Judge Garcia and Judge Pillard recognized. Energy Harbor has conceded that the 300 megawatts were included in the calculation. They just don't like where we included them. And they even concede that every other aspect of the calculation, as was also recognized in the argument earlier, every other aspect of this calculation is done on an aggregate basis. So from PJM's perspective, what really matters is the amount that you are committing to the market, and can you meet it? You're making that commitment, and we don't really care whether you run SAMIS 5 and SAMIS 7 flat out and run SAMIS 6 just a little bit, or you run them all at 50%. That doesn't matter. And so because we haven't disaggregated the calculation in any other way, it would be incongruous to disaggregate the calculation for the one the one reason to determine whether it's the sole outage for a particular, unit in that calculation.
So the balancing ratio is per event, right? Per need for the capacity across PJM. They apply a balancing.
They
But
apply.
it's like we've had to rely on capacity contracts to meet the energy needs of the consumers because of Winter Storm Elliott. And in deciding who to penalize, there's the balancing ratio as this is done off the top, basically. Nobody was able to operate or across the fleet, there was an average shortfall?
I think the way PJM would express it is that, okay, so the balancing ratio applies to the expected capacity. And the expectation is
System-wide capacity. And then-
fleet-wide, yeah, right. And so the expectation for their megawatts is discounted, for lack of a better word, by the overall percentage of the fleet that PJM needs to call on at that interval.
Is it an average or it's just, so PJM has contracted for, it has a 100% of capacity contracts
Mhm.
altogether. And it says,
Right.
this storm was an 85% serious storm. In other words, it required us to draw an 85% fleet-wide. And so we're not
Exactly.
going to pretend with respect to Energy Harbor that it was a emergency that required us to draw on 100% of their resource. So it's basically, it was enough to feed the customers to use 80% of our aggregate capacity that we had contracted for. Got it.
Yeah, I think that's right.
So it's not about, unlike unforced capacity, which is about failures, the balancing ratio is about need.
The balancing ratio is what PJM called on. It's a measure of the percentage of the available resources that PJM ultimately needed
Found
to
and
call
needed
on
to
to
call.
meet this emergency.
Got it. Anything right? All right, thank you.
Thank you.
And I think, once again, we managed to question you and keep you up at the podium longer than your allotted time, but we'll give you a couple of minutes if you want it for rebuttal.
Yes, thank you, Your Honor. I just have a few short points to make. Your Honor, you had asked about deference. Our position is that it should be limited. And the reason for that is because
It should be what?
it should be more limited. So a review of the tariff language here does not require technical knowledge. It doesn't require industry knowledge. It doesn't require the expertise that FERC would have to offer. As counsel for FERC actually acknowledged, the interpretation can be made based off the language that is in the tariff. I did also want to respond to
Can you be more concrete about where you think a non-deferential approach would make a difference for your client?
Well, in our opinion, the tariff language is clear and it should be just based off of the plain language of the tariff. We believe that the order was conclusory in finding that the resource should be the SAMS facility, because it ignored basically the operational realities of the facility. It ignored the fact that the outages are requested and approved on a generating unit level. And so this case is about an interpretation of basically a contract. And so while FERC's interpretation may be entitled to some deference, really the interpretation of the language at issue here doesn't require the technical knowledge and expertise that FERC has to offer. Okay. The second point I just wanted to respond to is, Your Honor, you had asked about paragraph 26 of the FERC order, J189. And in that paragraph, it said, this exemption applies only to the extent a resource on which the capacity resource is based is on a generator maintenance outage. And the resource was unavailable solely because it was on such an outage. And it goes on to find that the maintenance outage was not the sole cause of the inability to meet the expected performance. So this seems to suggest that if a unit had both a forced outage and a maintenance outage in place, then it would not be eligible for the exemption under section 10AD. But in FERC's brief, FERC offers an example that indicates somewhat of a contrary position. And this is the example that Your Honor, you were asking about. And that is that even if a unit had a forced outage and a maintenance outage, in the example that they provided on page 33 of its brief, that unit would be penalized for the forced outage, but not for the maintenance outage to the extent that that maintenance outage covered the remainder of the performance shortfall. So I just wanted to note that because it appears to be a slight shift in their position, but
That seems consistent with their position as stated today.
as stated today, yes.
The inconsistency is between that and the order?
Yes, in the order on the complaint. And that's in paragraph 26, where they say,
I'm sorry, what's the inconsistency?
sure. So the FERC order says that the exemption applies to the extent that the unavailability is based solely on the generator maintenance outage. And then it goes on to find that the maintenance outage was not the sole cause of the inability to meet its expected performance as the tariff requires. So when I read that, it seems to suggest that if there is a maintenance outage and if there's another outage in place, regardless of how it is applied to the performance shortfall, then Energy Harbor would not be eligible for
I'm
the
understanding them
exemption.
to be looking at increments of outage and that the ultimate increments after the forced outage that were unavailable solely because of the maintenance outage. And that's why those would not be penalized.
Okay, thank you, Your Honor.
Okay, great. Thank you.
Okay, may I make one more final point? I just want to reiterate that Energy Harbor bid in the full output of the SAMUS facility. What it was committed, what the capacity commitment that it had was a portion of that full output. Energy Harbor was not paid for the full amount. The amount that it was paid for and that it had an obligation to provide is the 1036 that we have been discussing.
PJM says your committed capacity was calculated based on the installed capacity that you bid in. Do you dispute that?
The committed capacity is basically what clears. There's a market clearing price and all of the units are cleared based off that level. So yes, the committed capacity is a portion of the installed capacity, but our position still remains that the committed capacity is the relevant portion that needs to be.
I understand them to say that when they decide how much committed capacity to accept, require, pay for,
Yes,
they do it in reliance on the installed capacity and a calculation based on your historical forced outages. Do you dispute that?
thank you. And so in closing, if, PJM provided prior approval for a resource to go out on a maintenance outage, that resource just should not be penalized for the unavailability.
Thank you.
Thank you.
Case is submitted.
Honorable forecast stands adjourned until Monday, February 3rd at 9:30 a.m.